Good morning, everyone. On behalf of the Center for Climate and Environmental Studies, Community for Academic Research and Development, it gives me immense pleasure to welcome all our distinguished dignitaries, members of the conference evaluation panel, academicians, researchers, policymakers, environmental professionals, climate experts, practitioners, students, presenter participants, and viewers joining us from across the globe. Today marks the technical session 1 of the South Asian Conference on Sustainability and Climate Justice 2026, a flagship international academic conference organized by the Center for Climate and Environmental Studies, Community for Academic Research and Development, in collaboration with the United Nations Environment Programme and the International Union for Conservation of Nature, and part by the Center for Development of Intellectual Property and Research. The conference provides an international academic platform for engaging with some of the most pressing challenges of our time, including climate change, environmental sustainability, climate justice, environmental rights, ecological conservation, sustainable development, climate governance, environmental policy, and the transition towards a resilient and sustainable future. The conference brings together scholars, researchers, academicians, policymakers, practitioners, environmental experts, students, and other stakeholders from diverse jurisdictions to share research, exchange perspectives, and contribute to meaningful dialogue on sustainability and climate change. Before we commence the presentations, I would like to acknowledge the distinguished members associated with today's academic assessment. Today's presentations shall be evaluated by the Conference Evaluation Panel and the Board of Assessment, who are presently present backstage and will assess each presentation in accordance with the prescribed conference evaluation criteria. The technical session 1 shall be conducted under the supervision of the Secretary Ma'am and the executive members of the Community for Academic Research and Development and the concerned Conference Secretariat. We extend our sincere gratitude to all our evaluators, experts, and members of the academic and organizing committees for sparing their valuable time and contributing to this important international academic exercise. Before inviting our presenters, kindly allow me to briefly explain the presentation guidelines. Each presenter has been allotted 5 minutes for the presentation. The presentation timer shall be strictly followed. I request all the presenters to keep their presentations concise, structured, research-oriented, and academic. Presenters are requested to ensure that their microphones are switched on and their presentation screen is shared before the commencement of their allotted presentation time. I would also request all participants to maintain decorum during the technical sessions and allow each presenter to complete their presentation without interruption. We shall now begin with our presentation session. I would like to invite our first presenter, Ms. Tensi, to present their research before this distinguished international academic forum. I request you to kindly switch on your microphone and begin sharing your presentation.
Am I audible?
Yes.
Yeah, okay. Is my PPT visible to everyone?
Yes, it is visible.
Yeah, okay.
Participants, you are not visible.
Okay, let me just look into it. Just a second. Am I visible?
No, you are still not visible clearly.
Yeah, my camera is a bit blurry because of
Okay,
something I
all right, you
pasted
can
long
initiate.
back. Yeah, yeah. Okay, thank you so much. So basically, my research is on comparison of two dams, Sardar Sarovar Dam and Hirakud Dam. So it is a comparison of the pre-construction promises and what was actually delivered after the construction of the dam was completed. So primarily to compare these dams, 5 parameters have been taken: the cost of the construction, the time of the completion, the irrigation promised, the hydropower promised and what was given, and finally the displacement. So these are the 5 parameters which have been chosen for the comparison of these two dams. Now, primarily, the reason why I have selected these two dams is based on 6 different criterias. So, number one, as per the National Register on Large Dams, they must be classified as a large dam. So Sardar Sarovar Dam and Hirakud Dam both have been classified as large dam. Not only that, they also must be classified as an important dam. Both these dams are classified as important dams. Then they must not be submerging an area which is going to be solely limited to one state. It must have multi-state submergence, and again, both these dams fulfill that criteria. Again, next criteria for for my selection was the dam should not be solely for one particular purpose, but it should have multi-purpose, and both these dams again qualify for these criterias. Now, also, I did not want to choose any dams which were constructed around the same time. So one of the dam was around the time of independence, and the other dam was nearly roughly 10 years back. That is Sardar Sarovar Dam. Now, one of the most important thing that was for my dams was the tribal displacement must be an important criteria, because usually in developmental projects, the tribal communities are displaced and the project gets complete, but it remains a huge question whether the displacement has been carried out properly, whether the rehabilitation and the resettlement has been done properly, because only then can we call a project truly sustainable, when it has justified not just its economic cost but also the social cost which is going to come along with it, right? So my paper largely is bifurcated into six parts. The first is the introduction, the second is the methodology, which I just explained that what and how I selected everything, the five parameters on the basis of which I will be comparing, and how I selected both the dams, right? Then I will be delving into the historical aspect of it, how the project was actually envisioned and it shaped and it came about. Then what was the actual promises which were made, that it is going to provide this much irrigation, it's going to provide this much hydropower. Yes, ma'am. Audible? Yes, ma'am. Not audible?
No, no, you're
Participant,
audible. Please
you can
continue.
continue. Yes.
Yes.
Please
Participant, kindly
continue.
continue.
Yeah. Oh, my other meeting is. Let me just close that because it's bothering me a bit. Just a second. Yeah, I'm so sorry because there was another meeting which was going on. It bothered me. I'm so sorry. So the pre-construction promises and the actual deliverables which happened in reality. And then finally, the conclusion is what I will be talking about. Now, in terms of historical background, the dam, Sardar Sarovar Dam, has been built across Narmada River. Now, Narmada River is among the 400 rivers which is a part of India. Now, this project, Sardar Sarovar Dam, was a part of a larger project which said that there will be 30 dams which will be built, 135 medium dams and 3,000 minor dams. So this Sardar Sarovar Dam was a part of that 30 large dams. The foundation stone was laid down back in 1961 by Jawaharlal Nehru, and the project got completed in the year 2017. So
Participants, you have
almost,
2 minutes left. Just proceed with your findings.
yeah, almost 56 years was spent to make it. Whereas if you talk about the other river, it started in the year 1948 and it completed within 10 years. Now the construction promises, pre-construction promises were, estimated cost was around 6,000 rupees, and the time of completion was roughly 10 years, sorry, 5 years for Hirakud Dam, and the estimated irrigation was 1.9 million hectares in Gujarat and 70,000 hectares in Rajasthan, while in Hirakud it was 1 lakh acres roughly. Then estimated hydropower was 1,450 MW, and like that 350, sorry, 3 lakh 50 kW for Hirakud. Now, the estimated displacement was of 235 villages in Sardar Sarovar, and Hirakud was 285 villages. If you compare the actual thing which has happened, the cost of the project came down up to 60,000 crore, which was almost 9 times the amount that was estimated. And in Hirakud Dam, the amount was almost 100% jump. That was almost a double of what was estimated, from 47 to almost 100. In terms of time of completion also, if you see, Sardar Sarovar Dam took almost 56 years to complete, while Hirakud Dam was completed within 10 years, but the estimated time was 5 years initially. But roughly for any large dam to be completed, it will take roughly 10 years, so it is kind of justified also. However, what was promised was not given. Same with the irrigation. Sardar Sarovar Dam has given a lot of irrigation, that I would not deny, but still it has not completed 100% of the target. It is still 94% of the target. While Hirakud Dam has not just given anything positive, but rather gone in negative. It is 40% lower than what was promised. Then, in terms
Sorry
of
to interrupt.
hydropower, yes, ma'am.
Yeah, just a reminder, your allotted time has now ended. Please conclude your
Okay.
presentation.
Yeah, just 1 minute I'll take. With hydropower, 85% of the target has been achieved and 50% less with Hirakud Dam. And in this is a major thing, Sardar Sarovar Dam. Even in the year 2024, there was a PIL which was filed, stating that the rehabilitation has not been completed when the dam was completed in the year 2017. So almost 200 times the people have been displaced, which was estimated. And even for Hirakud Dam, which was completed decades back, there was a complaint which was filed in NHRC in the year 2017. Both these cases are pending. So, in conclusion, everything that was promised has and not been delivered, and whatever we call in terms of sacrifice and development was largely incomplete. And I personally feel that development projects should not defy the ideas of development and sustainability, and the nation's progress is not really measured by the heights of dams, but rather whether they are able to do something for the people who have been displaced. That's it. Thank you, everyone.
Okay, so participant, my one question to you: what do you understand by the development in respect to sustainability?
Whenever we talk about development, it should not be in isolation with respect to economic development, right? It should be in a holistic manner, wherein we are also including social development, and we are talking about economic development, we are talking about environmental development, we're talking about cultural development. But what happens is, often in various infrastructural projects, the economic development takes a priority, and all these larger aspects, the cultural aspect maybe, or the social aspect, takes a back seat. Even if you talk about Sardar Sarovar Dam, it was completed in the year 2017, and even in 2024 there have been cases which have been filed stating that the registration is not complete. The dam which was completed around independence, even in 2017 there are complaints stating the same thing. So largely the priorities is getting reflected. So the idea of development is very narrowed down to economic perspective. Even if on paper they say that it is a developmental project for everyone, it is not really for everyone, but rather just for the state.
Okay, thank you for your presentation. We can
Thank you
move
so
ahead with
much,
the next.
everyone. Thank you.
Yes. Up next, we have R. Sandhya.
Good
You can
morning,
go
all.
ahead with your presentation.
Yes, ma'am.
Participant, you are not visible.
Yes, sir. Sir, am I visible?
Yes.
So my PPT is visible?
Yes, it is.
Yes. I'll start with my presentation, ma'am. Uh, Good morning, everyone. I'm R. Sandhya, a postgraduate student in economics at Stella Maris College. It is my pleasure to be here and present our paper. So I'll be discussing on the estimation of economic value of biodiversity supporting services of mangroves in India. So for the introduction part, mangrove ecosystems are among one of the most productive ecosystem in the world that forms in the interface of land and water. They are biologically they are diverse due to the extent of niches and habitats they sustain, and they act as nursery and breeding grounds for many species. So, according to the India State of Forest Report 2023, India has around 4,99,168 hectares of mangrove cover with major formations in Sundarbans, Godavari, Krishna deltas, Gulf of Kutch, and Andaman and Nicobar Islands. So, the economic valuation of these biodiversity supporting ecosystem services helps us to often value this unpriced benefits visible and support informed conservation and policy decisions. So the research gap here is there are numerous studies that have highlighted the ecological significance of mangrove ecosystems, but comparatively there are fewer studies that have estimated the economic value that these biodiversity supporting services provide, especially at a national scale. So this study addresses this gap by estimating the biodiversity supporting service values for the Indian mangrove ecosystems for 2019 and 2023. So the objectives is to estimate the economic value of these services, to compare the estimated value of biodiversity supporting services between the 2 years, and to assess the implication of the changes in mangrove cover for the economic value of biodiversity supporting services. So the methodology is as follows. The study area is done in the mangrove bearing states and union territories of India. And the data is from the India State of Forest Report, which is published by the Forest Survey of India biennially. And methodology adopted is based on an Indonesian study. The equation is used to estimate. So it is BM is equal to DV into MA. So the BM is the total economic value of mangrove biodiversity, and DV is the estimated value of biodiversity per hectare, and the MA is the mangrove area in hectares. So the biodiversity value per hectare, that's the DV component, is again taken from a study that is that was conducted by University of Nairobi and UNEP. So for according to that, the biodiversity value of mangrove per hectare is US dollars 40, and while we convert it into our currency, we get rupees 3,814 per hectare, and this is how the calculation is done. And with this we can get the entire values for each states union territories with the given hectare values. And the results show that this methodology is entirely based on benefit transfer method. It is a method that is used to estimate the economic value of environmental good from the economic value will be taken from the existing literatures and studies. So the results of this study conclude that there is a 0.34 percentage increase in the biodiversity supporting service value in the from the mangroves ecosystem, and the findings so the findings indicates that the increase in mangrove cover between 2019 and 2023 corresponds to a small increase in the estimated biodiversity supporting service value. This highlights the economic significance of maintaining and conserving the mangrove ecosystems, as when this ecosystem is degraded or there is a loss in the mangrove habitat, and it can reduce the ecosystem's capacity to support the biodiversity that it is supporting now. And so the policy recommendations that I would give is integration of biodiversity supporting service into the mangrove conservation, and encourage the conservation of mangroves in states and UTs that already have a large biodiversity, and schemes such as MISHTI, Mangrove Initiative for Shoreline Habitats and Tangible Incomes, should focus on conservation of biodiversity in mangrove areas. And long-term monitoring of biodiversity can also support and can have a positive impact on biodiversity conservation, and the public private partnership model can be encouraged in this respect. For example, the initiatives of Godrej that was undertaken to conserve the mangrove ecosystem in the Piroj Nagar mangroves in Maharashtra serves as an example how private involvement can be encouraged also. So this is my conclusion. So the conclusion is by estimating the value of biodiversity supporting services, the study has highlighted the importance of biodiversity conservation and ecological restoration of mangroves in these regions. Thank you.
Okay, participant, what are the models you are taken into for the climate conservations?
Models in sensor.
Like, what are the reference, like the good practices across the world or across the nations? Have you taken any reference of such thing?
Yes, sir. One example I mentioned is in the policy recommendation itself. That was done in the Maharashtra region by Godrej company, and it has restored. It has also resulted in significant impact. And also, I have referred to one of the practice that was done in China to restore trees. So they provide uh, incomes to the people who are undertaking this restoration activities that are local communities. So we can adopt that also here.
All right, thank you for your presentation.
Thank you, sir.
Next, I would like to call upon Professor Atul Singh for their presentation.
Yes, I'm here.
Yes. Please share your PPT, sir.
Yeah.
Participant, we lost the connection with Professor Singh.
Yes. Okay, we can move ahead with the next participant.
Yes.
Next up, we have Pernil. Yes, Miss Pernil, you can start your presentation.
Participant, you are not audible.
I'm not able to share.
Yes,
Yes, your PPT is visible.
yes.
Okay.
Professor Singh, we had lost connection with you. We'll be taking you next. We'll be taking you next. Yeah.
Can you see my PPT?
Yes, it's
Yes,
visible. You can
yes, you can
start
start.
with your present. Yes.
So the title of my paper is Global Plastic Treaty and Responsibility of Transnational Corporations. So it's a doctrinal research. So as you know, plastics are synthetic polymers which come from crude oil and gas, and they are non-biodegradable. About 79% of plastic waste ends up in landfills, natural environments, polluting oceans, natural ecosystem, endangering marine life, and it has transboundary effects. And this is where the question of international law comes in. Now, we all know that the negotiations on plastics treaty is ongoing. So there are two main coalition of countries. One is HAC and the other one is the LMG. HAC includes countries like Norway, Rwanda, UK, France, and they all want common globally binding obligations, and they also want restrictions on the production of plastic. And the other group is includes Saudi, China, Russia, Iran, Kuwait, mainly the countries uh, that produce oil or they produce plastic. So they don't want any common globally blinding rules. They want voluntary non-binding commitments taking into account natural circumstances and capabilities. They want focus on waste management and circular economy. They don't want any restrictions on production. So, what's the need of corporate responsibility in it? Right now, the treaty is focused on the state obligations. Now, when we know that plastic, just like any other commodity, it's dependent on its demand, right? So, if the imposition is done of restrictions is done on plastic production, but uh, not on the demand, then it will not work on the ground because demand will continue to drive the production upward. So if demand fizzles out, so will the production. So because when you talk of logic of capitalism, it's the generation
of surplus value, that is profit. Uh, Many studies have found that the global packaging industries uses the most plastic and causes the most plastic pollution. So this is where the need of corporate responsibility comes in. Meaning of corporate responsibility: TNC should not only be responsible to their shareholders, which they usually are, but also to the needs of the international community based on internationally recognized values. Can TNC be held responsible under international law? So there is a debate among the scholars. Scholars like Brownlee, they stick to the traditional object-subject dichotomy of international law, and they say only states are the subject. But there are also scholars like Rosalind Higgins who emphasize that there is a need to move beyond this dichotomy, and they say that it has no functional purpose. They say that the question which should be considered is the participants in the international legal process, because that is in sync with the real world practice. And if you go by that standard, TNCs are definitely participants in the international law, and they enjoy rights under international law, just like under international investment law. So they must have responsibility to. Uh, the one thing that I argue in this paper, one obligation that that the treaty needs to impose on the TNC is the procedural obligation of transparency. Transparency has become a crucial component of the modern MEAs. Scholars like Gupta have called it global environmental governance or governance by disclosure. Now, what's the need of transparency? So, environmental impact information can empower the public by informing them about who and what is degrading their environment, degrading their environment, and enables them to ask the right questions to right stakeholder. So, there is also a study by UNEP in 2004 which also emphasizes the need for transparency. Paragraph 4 of the draft code of conduct on transnational corporation also emphasizes the need of transparency. So it is submitted that the plastic treaty should impose an obligation of transparency and mandatory reporting of plastic production, use, and disposal on TNC, especially the FMCGs. When it comes to substantive obligation, the trend now under international environmental law is the soft law. So substantive obligations go by soft law. Soft law come in the form of declarations, resolutions, decisions of the Conference of Parties, MEs, or international standards. Now, one substantive obligation that needs to be part of the treaty is the obligation of due diligence, which includes the obligation to prevent plastic pollution by ensuring cleaner production practices. And the sustainable packaging of goods and products is also a part of cleaner production practices. Therefore, the TNCs should be required to adopt sustainable packaging. To conclude, only making states liable will not be sufficient, because plastic pollution is a transboundary issue, and it happens even the places we call as global commons, which do not fall within the jurisdiction of any single state. And when it comes to TNC, they can no longer evade responsibility to the international community by pleading the object subject dichotomy, because TNCs are participants in the international legal process. Production is driven by demand. A high demand for plastic comes from the FMCG industry. Thus, it is submitted that there should be an obligation for binding reporting on measures taken for the transition to sustainable packaging, as well as investment in research into renewable resources for new packaging solutions. Thank you.
Okay, thank you, participant. I don't have any question. Thank you. We can move ahead with the next host.
All right. Up next, we have Professor Atul Singh.
Yeah. Am I visible?
Yes, sir, you are.
My slides are visible.
Yes.
Okay. Now, I must say, invasive species world over are recognized as the critical issue of the Anthropocene, driven by international trade, the rapid human mediated movement of species from one country to another, and climate change. Aquatic invasions are global phenomena, and it is highest in Asia when we consider freshwater ecosystems. My topic of presentation is aquatic invasions in freshwaters, unraveling biodiversity and ecosystem stability. You see, in India, over 600 non-native species have been introduced, fish species have been introduced, and some of them are invasive. We have identified them, and as per our methodology, 16 species are invasive, and they are available in several river basins in the country. And we have we have measured the invasion intensity of these invasive species in different river basins and found that aquaculture, diversification with non-native species, urbanization, river regulations, habitat degradation, and several other factors have caused aggravated the invasion in intensity. And the major hotspots are lower Ganges, Godavari, Krishna, Kaveri, and lower Mahanadi. Over the years, next. Over the years, the invasion has been, a serious, it was scaling and has become a serious issue in the country, and it is damaging biodiversity and the ecosystem functioning. The commonly invaded non-native species are, it is depicted in the slide, you can read it: tilapia, common carp, bighead grass carp, then silver carp, and alligator carp, and gambusia. These are some of the species which are commonly available in major river basins. And if you look at the presence of invasive species in different river basins, we found that the Ganga, Brahmaputra, Godavari, and other basins are widely invaded, impacting biodiversity and ecosystem. It was observed that more than 56.52% of water basins are invaded by invasive species, indicating a high degree of habitat suitability for their establishment and spread. Invasive species population dynamics, it shows that the epigenetic plasticity, hybridization, and adaptive evolution is at high rate, are combined to describe how the invasive populations of non-native species can break the founder effect and initial genetic bottleneck to conquer new environment. Nature is found to be unstable through molecular shifts in invasive taxa, and that has potential to cause much ecological disturbances. Once the invasive species attains its population abundance, it starts adversely impacting the biotic integrity and species richness. And these are some of the commonly affected native species. You can see Indian major carp, catfish, particularly the endemic one, the Clarius mangur, Clarius dusumeri, Mahashiri species, snow trout in the Himalayan region, pearl spot in the southern western Ghat. And these are some of the species they are affected. So what I did, I started working on a model that is a structural equation model, and I tried to work out if by this model whether anthropogenic disturbances and the ecosystem degradation, they are how they are having traits of. So it shows that the anthropogenic disturbance is primary driver of freshwater ecosystem degradation, exerting a strong positive effect on both habitat degradation and also on water quality. Habitat degradation strongly promotes invasion intensity, it was observed. The model explains 81% of the variation in ecosystem stability, indicating high explanatory power and emphasizing that biodiversity mediates much of the ecological impacts of aquatic invasion. Then how invasive species they are impacting, it has got three dimensions. One is ecological, the other sociological and social, and the third one is economic. The invasive species ecological dimension covers the loss of native species and fish diversity, disruption of ecosystem functioning, and altered food web. So this is really important. And apart that, the economic dimension is very, very important because it causes severe economic losses concerning the management issue and also the retention of the native species in the native habitats. So, what we need to do, there is an urgent need to develop good governance to resolve the scientific and social conflicts on the management of invasive species, which may arise from clashing perspective on ecological, ethical, and practical issues. These conflicts, often called destructive when they hinder management, such as large scale eradication of fishes. This will foster the inclusiveness of aquaculture and fisheries growth. This will also ensure accountability and responsible aquaculture and fisheries. So, what we decide, we have developed a national invasive species strategic plan, and that covers a policy on invasive species to be guided for guiding the national as well as regional action towards mitigating the threats of invasive species and reducing their pressure on biological diversity. These actions can help us achieving the target of Kunming Montreal Global Biodiversity Framework, where it is mandated to reduce at least 50% of fish invasive species by 2030. And it will also cover sustainable development goals 2, 3, and 15 related to invasive species. So such action will definitely, create a dent towards the loss of biodiversity and aquatic resource integrity. So we need to immediately start working on these lines. And thank you so much for your patient hearing. Save our fish biodiversity from aquatic invasions.
Okay, Professor Singh, I have one question for you. Specifically,
Yeah,
when we
sure.
looked into the specifically when we looked into the invasive species and its regulation in India. So
Yeah.
time and again, the government of India, in number of reports, they had hinted upon coming up such detailed regulation relating to it. But we see it has been more than 3 decades when this research has been started in this invasive species, but very minutely law has not been taken up in that note. So I would like to ask you, what are the countries you looked into when you try to refer up that the regulation as good to take it as a model?
Yeah, in fact, if you look at the Asian countries, because I worked in FAO also, and we created a collective approach how to manage it. Because once invasive species has gone into a open water system, it is very difficult to contain it. So what is needed? A collective approach to keep it at the minimal abundance, so that the impact should be reduced to the lowest level. So that is the only approach where we can work. And the second, as you propose, that there is no legislation in India, and even if you look at the Asian country, hardly any legislation is working to contain the invasive species. It's a major drawback. So we need to develop a regional policy also, how to manage it, because aquaculture is growing, and promotion of aquaculture through introduction of such in is species from one country to another, it is happening. So we need to develop a regional action plan also. It is very important. and there is as such no legislation in India as well as in the adjoining country.
Okay. Thank you for your presentation, Dr. Singh.
Thank you. Thank you.
Now I invite Ms. Noholi Bonerjee for their presentation.
So hello everyone, I am Nahali Banerjee. I am from Jadavpur University. I am a UG4 student. Today I am going to present on the topic civic behavior and its degrading impact on Indian climate laws. Uh, Instead of throwing facts, I actually wanted to show all of you that why is this topic required. These images speaks for itself. The amount of waste disposed in a very negligent manner shows the condition of civic behavior in India. So my question through my research is, does civic sense make sense? Now, first of all, people might ask, what is civic sense? As a sociological concept, it can be understood as the daily behaviors and morality held by individuals in a society, community, and public spaces. It dictates how citizens now direct themselves in shared communities in public spaces based on their fundamental values of social accountability. I analyzed this concept through Garrett Hardin's Tragedy of the Commons concept. This is also a sociological concept where it highlights how rational individual actions deplete shared public resources. For instance, in India, households maintain high personal hygiene but neglect public spaces, creating a sharp divide between the private cleanliness and collective environmental degradation. Now through a legal perspective, I have chosen three articles from the Constitution. Article 21, which highlights a clean and healthy environment as a fundamental right. Article 48A, which originated through the 42nd Amendment in 1976. The Constitution sets guidelines for the state to protect and improve the environment and safeguard forests and wildlife. And Article 51 AG, that is a fundamental duty requiring citizens to protect and improve the natural environment while showing compassion for living organisms. These are the landmark judgments which I have chosen for analyzing the issue. First is Subhash Kumar versus the state of Bihar, where the right to life under Article 21 was highlighted, and emphasized and focused on the enjoyment of pollution-free water and air for the sustainability of life. MC Mehta versus Union of India, also known as the William Gas Leak, which emphasized the absolute liability of the industries. And MK Ranjit Singh versus Union of India case 2024, where it highlighted the right to be free from the adverse effects of climate change, and through articles for 14 and 21. The main point behind choosing these topics is to show a link between fundamental rights and global climate governance. These are the key environmental acts. Due to time constraints, I'm not going through this, but you can see that these are also important in the climate change and sustainability aspect in India, along with civic behavior. Now, for the global climate provisions, for the global compliance, although Article 21 was initially used for personal liberty, the MC Mehta case highlighted the right to life also needs clean air and fresh water for survival. This aligned with the globally recognized provisions under UNDP, United Nations Developmental Program, and the United General Assembly, where they discuss about the climate change. For the precautionary and the polluter principles, under the Vellore Citizens Welfare Forum versus Union of India case 1996, the Supreme Court formally integrated legal doctrines such as precautionary and polluter-based principles under Article 21 to hold polluters responsible for their actions. And the Minos Oposa was the Secretary of the Department of Environment and Natural Resources, 1983. This is in Philippines. As a comparative analysis, I chose this case where the court argued that the assumption of ecology existing in the inception of humankind is what led to its negligence. It also stated that children were also entitled to sue on behalf of future generations based on intergenerational responsibility. Now, what went wrong? What are the policy challenges? First of all, through a sociological concept known as norm activation model introduced by Schwartz, a contrast is seen, as mentioned earlier, between private and public spheres. Along with legal failures has also been observed, such as the failure of NGTs, national tribunals, which struggle with weak enforcement, administrative delays, and judicial limitations. What are the judicial limitations? The tribunal is restricted from hearing matters under the 1972 Wildlife Act and the Indian Forest Act 1927. It heavily relies on the state pollution control boards for to lead and addressing issues such as lack of resources, funds, and human capital to operate the tribunal effectively. Polluter pays is not enough, although it can be followed religiously through theory. This often fails to restore environmental damages, leaving zero consequences. One of the examples can be the Great Nicobar
Kindly,
project and the
Stephen, kindly
structural
conclude.
challenges. Excuse me, sir.
Yes, kindly conclude. You had exceeded your time.
Sorry. And another is the development versus nature challenge. For conclusion, I would like to highlight the policy recommendations. These are the measures that can be implemented, such as the ward monitoring, challenging legal assumptions, creating a balance between civic responsibility and fundamental duties under Article 51 AG, and beyond polluters pay, that is expanding beyond polluters pay penalties by integrating strict measures within Article 21's right to a clean and healthy environment, and scaling up tribunals, expand the NGT tribunal using digital crowdsourcing for violations and GIS mapping for real-time infrastructure detection. It is not that we don't have any positive examples. We also have positive examples such as the Northeast India. We just need to open our eyes and be responsible for our own environment. Thank you.
Okay, thank you, participant. I don't have any question for you. Thank you.
Thank
All right. I would like to call upon Ms. Gauri Singh for the presentation.
Ma'am, I hope I'm audible and visible.
Yes. Please share your PPT.
Ma'am, you are not audible. Shall I present my screen?
Yes.
Ma'am, if somebody can tell me if my screen is visible, if my presentation is visible.
Yes, participant, you can start. Your presentation is visible.
All right. Thank you so much, sir. Good morning, everyone. The topic that I will be
PPT
presenting.
participant, your PPT is not visible. It is just a screen which is visible.
All right, sir. Sir, I am presenting from Keynote. I think that is not supported. So I have a PDF version of this presentation itself. I will try and present that.
If you have that PDF, you can open up this PDF. Since you were sharing screen, it would be visible to us.
Sir, is it visible, the PDF?
No,
No,
not
it's
yet.
not visible. You might have not provided permission to your whole device.
All right, sir. Sir, I'll try and look into it.
Yeah. To all the participants, kindly keep your PPT slides loaded at it takes time. We had already exceeded few minutes. Yes,
Sir,
your
is the
PPT. Yeah, it's
all
visible. It's loaded. You can start.
okay? Thank you so much, sir. Good morning, everyone. The topic that I will be presenting on is with regards to climate finance in the sense of climate negotiations. So, the topic is titled From Rio to Baku, the Evolution of Climate Finance in International Climate Negotiations. Let me start with a very simple question. What does it actually cost to save the planet? And since 1992, we have been trying, or the world has been trying to answer this question with dollar signs. And today I wanted to walk through that story. And it started all the way in Rio. And now we have Baku as the most recent conference about it. And this is basically what traces the whole story of climate finance. So, what is climate finance? If I try and remove the jargon and explain it in very simple words, it's just money which is moving from developed countries, mature governments, and banks and investors to the countries that are more needy, or that in a very common sense we say now or refer to them as the global south. So, the money is moving from the global north, which is the developed countries, to the global south, and the journey that has been from Rio to Paris. So this idea has taken over 30 years to build something that now we can refer to as climate finance. So it started in Rio in 1992 with a very modest fund that almost nobody remembers now. The UNFCC was established. Then we had the Kyoto in 1997, wherein a market mechanism was brought into picture, which was basically a financial tool. Followed in the year 2009, we had the Copenhagen, wherein for the first time came the real numbers. So the $1 billion that we talk about, 1 billion US dollars that we talk about, quite often that the global north was required to pay to the global south. So in this conference was when it was brought into the picture. And then it was followed by the creation of the Green Climate Fund, which was basically required to deliver it, which was followed by, in 2015, the Paris Agreement, which finally wrote for the first time the finance responsibility or accountability into their agreement and into the legal architecture, basically. Moving on to who actually is responsible and who moves the money. So there are five primary bodies that are required. So there's Global Environment Facility, there is the Green Climate Fund, there is the Adaptation Fund, and there is a Multilateral Development Bank. And then there are private finances, which is basically there are some private organizations in every state, in every country, that helps provide that. So each of these banks and all of these funds, they basically have a different criteria. So based on that criteria, based on the different rules, based on the different speed, it is less of a single system, more of a crowded marketplace. And the fragmentation in itself has become a barrier. And why is that so? I will discuss in the further slide. So we have had the last three COPs, which have ended up achieving more than the previous 20 could. So in 2022, the COP 27 was held in Egypt, and it was for the first time that it called upon what the global south actually has demanded for decades. A loss and damage fund was created, which finally recognized that some harm simply cannot be prevented, and we cannot wait until there has been irreversible damage that has been done. So, which was followed again by COP28, which was held in Dubai, and it helped operationalize the structure that was talked about in COP 2027. In COP 27, which was held in 2022, World Bank was given the responsibility to help allocate these funds. And then the most recent conference that we had, which was COP 29, which was held in Baku, and it set a new target. Now, this is where the number from $100 billion was hiked up to $300 billion by the year 2035, which was which aim was increased primarily. And that was done because the previous $100 billion that were promised were not delivered Exactly. And that is one of the problems that we have been facing. Now, if I talk about climate finance and global south, so numbers on a page actually mean nothing unless and until they reach the people who actually require it. So, from global south, for the global south or the developing nations, it was never really about charity, and it shouldn't be treated as charity. It was more about the survival, because there were islands that are drowning, that are facing ocean rising levels, and their homes are being destroyed. Then there are farmers in Africa that are facing drought problems. There are countries like India who have been trying to build their own adaptation fund. So if there is ever a climate calamity that is faced, so this fund, adaptation fund, is basically helped to counter it, and second, to build upon it, so that they can fight off these natural calamities in a more structured and a more better manner. And these just does not is limit this is just not limited to loans. This is also with regards to the grants that can be provided by the global north to the global south.
Sorry to interrupt.
I
Please
would
conclude
also
your
like to
presentation.
focus more upon the challenges that are being faced. So
Participant, kindly conclude your presentation. You had exceeded the time.
all right, sir. Sir, I will conclude the challenges and the conclusion in one. So, one of the most uh, challenging parts that we face is that the money that is to be, or that has been promised to be allocated, is not delivered. Loans is something that is focused upon, but grants that was actually supposed to be delivered by the developed nations has not been done. There is very little transparency, and one of the challenges that basically tops everything is the fact that the procedure is very complex and very brutally complex, so it becomes very difficult for the developing countries to actually apply for these things. And as a concluding statement, I would say that this whole idea of climate finance is morally brilliant, and it is what actually the world needs right now. But till the time this procedure will not be simplified more, it will be very difficult, and these barriers will not be able to be countered. So my presentation basically concludes by saying that the procedure for applying for climate finance and for the allocation of grants and loans needs to be more simpler, so that many countries and much and more countries can apply for these financial aids in order to help deal with climatic stresses better. And so that is my presentation.
Okay. The panel has no question for you. Thank you.
All right. Thank you so much, sir.
All right. Now I invite Miss Sana Mittal for the presentation.
Hello. Hi, is my screen visible?
Yes.
Hi. Sure. So, hi, I'm Sana. Good morning, everyone. My paper focuses on the theme climate justice and human rights, and asks the question: is energy justice a trade off against uh, growth, security, and climate action in India, or the method through which those goals should be pursued? The paper has built an argument, applied it to India, and taken on the strongest objection, ground, grounded it in real schemes, and closed it with policy implications that has been tied to this conference's agenda. India's transition is usually framed as balancing four competing goals, which which are misleading because it implies that one goal must be sacrificed for the others. But so in this case, the paper uses the energy trilemma, which is of security, affordability, and equity, and environmental sustainability, as the World Energy Council and Indian policy documents define it. And crucially, it says that equity is already inside that framework and is not external to it. So the trilemma is inherently a justice question, and the core thesis draws on the fact that energy justice is a necessary condition for transition legitimacy and success, and it is not an optional add on. Drawing from Heffron, Macaulay, and Zazura de Rubin's energy justice metric, which quantifies policy as performance on affordability, health, and participation, energy justice breaks into three pillars, which are distributive, which says who gets access and who bears the cost. Then there is recognitional, which talks about whose needs are acknowledged, including informal workers, small farmers, and marginalized communities. And then there's procedural, wherein we ask who has a real say in transitions such as solar parks, transmission lines, and coal mine closures. Here, the paper uses the Destiny Knox point, which is a low carbon system can still be unjust, and says renewable expansion can cut emissions while leaving poor households with unaffordable electricity and workers uncompensated while communities being voiceless in planning. So decarbonization and justice are not the same success metric in one sense. India faces what the authors Josh and Dash call double transition, which means there is closing historical deficits in electricity and clean cooking access, while simultaneously building future system, renewable integration, storage, and electric mobility, layered on accurate climate exposures such as floods, droughts, heat stress, and energy policy must uh, serve mitigation and adaptation together. On the In addition to that, Ghosla and Dubesh argue that Indian energy policy can't rely on old growth and supply assumptions alone. They have to be redesigned around the social and ecological realities, uh, and justice has to be built within development and not wait against it. So, the strongest objection that the paper talks about is that India cannot afford justice first. It needs growth, jobs, and reliable power now, which is why coal power and short term subsidies get defended, which is valid, honestly, but this strengthens the case, not weakens it. India is an energy import dependent country, which means it heavily relies on imported fossil fuels and underpriced electricity, creating fiscal stress and exposure to global price shocks. Security focused policy still needs just design, or, or it will relocate the risk onto vulnerable groups. So basically, what this means is we need justice as a method of development and not justice instead of development. So the reframing needs to happen. In the paper, the four schemes are discussed, and which proves this point. So the Ujwala scheme, which gives LPG connections to the BPL households, but it shows the problem of recurring refill costs that push many back to biomass. This shows that there is access without affordability. The Subhangya scheme expanded electrification fast, but it created reliability, supply quality, and to pay remain ability to pay remain weak, especially in rural areas, which means there is connection without meaningful access. Then, and the Kusum and the Surya Ghar schemes promote decentralized solar, but
Participant, kindly come to your conclusion.
yes, please. Uh, and it skews towards the farmers and people who can already afford this. So there is the reproduction of inequality under the green label, and just that there are four pillars of transition wherein we need to take care of affordability, reliability, employment support, and real participation and regional balance. And on that note, I would like to end by saying that energy justice is not an alternative to India's growth story. It is what makes the story equitable, resilient, and credible. Thank you.
Thank you, participant. The panel has no question for you.
All right. I would like to call upon Miss Parvati for their presentation.
Participant, you are not audible and visible.
Hello, am I audible right now?
Yes.
Yes.
Okay, so let
Kindly
me
share
take.
your presentation.
I
Yes.
am processing my PPT. So, my topic of presentation is a very good morning to everyone. My topic of presentation is From Conflict to Coexistence, what Noel Kempf teaches us about wildlife governance. So, in this paper, the us remain represents the people of India, Indian citizens. So, from conflict to coexistence, what India can learn from Noel Kemp Mercado National Park. That's what I am going to deal. So, Noel Kemp Mercado National Park was established by the Fundación Amigos de la Naturaleza and Red community for the elimination of human wildlife negative interactions. So, man animal conflict is a main issue that India deals with right now. With climate change, it is also important that we have to find a solution for man animal conflict as well. So, the Mercado project was based on governmental institutions, financing, and local participation combined together for uh, making a solution for the man animal conflicts. So it was sorry, I'm really sorry. I'm really sorry for the disturbance. So mm it was involving local people for the like indigenous knowledge or indigenous voices through training and empowerment with ecotourism and in reduced hunting, fishing infractions, and all those things. So, Noel Kemp Mercado provides a model for eliminating human wildlife conflict. It was based on conflict to coexistence. Like from conflict through coexistence, we can find a solution for man animal conflict. So the governance lessons given by Mercado National Park was project was responsible governing bodies, durable finance, stakeholder engagement, democratic governance. These are the all the things that the governance lessons given by the Mercado National Park project to the Indian system. So, accountability and transparency comes as the basic thing for this. And coexistence is not achieved simply by declaring it desirable. It depends on the institutional design that supports both the ecological protection and human well-being. We have to consider humans as well as the ecological factors. So factors that have been successful, that have been helping for the successful running of this wildlife governance was coordination of government and local communities, long-term financial management projects rather than short-term projects, proper monitoring and adaptive response, trust and accountability. Through all these, Mercado National Park was being a model for policy making in wildlife governance in Bolivia. So, from this, what the Indian context is, that's what important in my paper. So, the Indian context of Mercado National project is building a community conservation adaptive management practice that will help the people to recover from the man animal conflicts. So adaptive management, fast compensation, habitat protection are some of the factors
which will help the people to recover from the man animal conflict. So, local trust, landscape planning, and the usage of indigenous knowledge to build a system that is running as a coexistence strategy towards man animal conflict is mainly learned from the Mercado project. So there is a shift from reactive conflict control to planned coexistence governance. So when we build a plan, it should be like, it's not like let the problem come to us, then we will react to the conflict. It's not like that. So it will be a planned coexistence governance model that will be built by uh, making a successful project. So, chasing animals is not the easy way to resolve human animal conflicts. We have to manage the governmental institutions, incentives, local trust, and landscape planning, and all the factors surrounding the man animal conflicts to make it coexisting and more resilient. So, for that, political participation, trust and accountability, community conservation measures, adaptability, management and proper monitoring, financial support, all are the factors. These are all the factors we can adopt to the Indian system. So from Noel Kemp project, the main points we can take, it's not like copy pasting that project.
You had exceeded time. Kindly conclude. Come to the
Yeah,
conclusion.
I'll conclude. This is my concluding point, that uh, we can't like literally go like copy pasting that system. We have to take some portions like community conservation, long term finance, and adaptive management for the solution of man animal conflict. A practical Indian version of this project would combine community led monitoring, fast compensation, habitat protection, and livestock safeguards. This is the main things we can learn from Noel Kempf. It's not about copy pasting that, it's just that we can take lessons from that through long term planning and all those things, but we have to build a system that is long term effective. Thank you so much.
Okay. Thank you, participant. The panel has no question.
Thank you, sir.
Moving ahead, I invite Ms. Sumati Narayan for their presentation.
Good morning, everyone. I hope my screen is visible.
Yes.
Uh, Today, I will be presenting on the topic of climate change as a test of global justice, where I would be discussing the need for international fairness in global north versus global south. To introduce my paper, I have discussed how climate change has amplified the pre existing global inequalities arising between global north states such as US, China, European Union, and between global south states such as India, Africa, and other underdeveloped economies. So, I would be discussing how the global south bears the burden of tackling the climate change. And in this paper, I have discussed 5 core concerns, starting with historical accountability, then the present day emissions, followed by climate financing, the international negotiations, and climate diplomacy. Uh, Coming to historical responsibility, as it is visible from the chart, developed countries such as United States, EU, and China have contributed to the most amount of carbon dioxide emissions on our planet. And therefore, we must adopt the beneficiary pays principle, which states that developed economies must compensate to the global south as they are benefiting from the emissions uh, released in the planet. Following on those lines, the present day global warming states that the greenhouse gas emissions is being majorly contributed by United States and European Union, and therefore the principle of intergenerational equity adopted by the UN comes into picture, which states that the future generation must not bear an unreasonable burden, and the present generation should use more renewable resources and protect the environment. Now the tool of climate financing has come into a very useful tool, wherein the global north states who have the financial capacity must compensate the global south states who lack financial and economic capacity to deal with climate change. uh, Next is the international negotiations, which we see through the implementation of agreements such as the UNFCCC, the Paris Agreement, wherein the both global north and south states have come together to achieve common targets in tackling the climate change effects. Recently, US has withdrawn from the Paris Agreement and has become a free rider, being a major emitter of the global greenhouse gases in the environment. Next is the topic of climate diplomacy, in which I have discussed in my paper how the global north and global south must come together and share on a common platform, raising their concerns on how global justice can be achieved by tackling the drastic effects of climate change. In my view, I see that the world has been divided into two parts, which is global north and global south, but we share one common climate system. And so it is our responsibility that both the global north and global south must come together and cooperate in tackling and fighting the climate change effects. So the path forward for the climate change would be to build a just climate framework, wherein we would strengthen climate diplomacy, followed by having technological transfer, and also supporting accountability and transparency among the countries, and understanding that having a shared international responsibility is crucial to achieve the goals of climate change. To conclude my presentation, we need a genuine collaboration between the North and South, as as it is a matter of global justice how we would use the scarce resources to fight the effects of climate change. And therefore, following global justice, we need fairness, equity, and shared responsibility. And and as India is also becoming a leader in various international negotiations, it has become paramount that global North and South must come together and harmoniously create a path forward. Thank you so much. If there are any questions for me.
Okay, participants, what are the country-specific policies you think that that can be taken as the model for the environmental problems we are facing?
So, talking with respect to India, we have our legislation in place, and we are also a signatory to the Paris Agreement. And we also derive our inspiration from developed economies on how they are tackling the climate change effects. So, there is no precise model, but we must adopt the measures in which our commitments and international obligations are being thoroughly followed, and we also get a chance to present our views on international platforms on how, being an developing economy, we need climate financing and support from the developed countries to tackle the drastic effects of climate change.
All right. Thank you for your presentation.
Thank you so much.
Next, we have Miss Jasmine Singh.
Am I audible?
Yes.
Yes, just a second. Is it visible?
Yes. You can start.
Okay, thank you. Good morning, everyone. So, actually, I had a video here which is unable to be played. I apologize for that. But this video was regarding the the phenomenon called stubble burning. Now, I'm a resident of Patiala currently, and this video was shot just a few kilometers from my college itself. I'm a victim as well as a witness of the air pollution which has been plaguing Punjab, India, for the past couple of years. And when I say Punjab, I mention not only Punjab in India, but also um, Punjab in Pakistan, as well as Bangladesh, that is the entire Indo Gangetic Plain. So, my paper will be examining what lacunae lie in the existing legal framework that we are unable to curb stubble burning, and is there an actual need to add a layer of criminal law to the current structural international environment law framework? If we look at the current trends in the Indo Gangetic plains, it's quite contradictory, and I'd say there's rather smoke without fire because, as per the government statistics, the stubble burning figures have had a steep decline in the past couple of years, almost a 90% decline in both India and Pakistan. Meanwhile, the AQI is on a rise. So, such a trend poses certain questions, which forms the core and the premise of my paper. The questions are: is the current framework in all of these countries which form a part of the Indo-Gangetic plain, are they well equipped to address any criminal liability if we are supposed to make any farmer or any government authority liable in a criminal law setup? And is there an actual need to add that criminal law setup in the first place? And if so, what shall be the forum for the same? To address the first question, that whether the current framework addresses a criminal liability situation, the answer is no. Because in India, if we look at the FIRs which are filed against farmers, it is done via generic provisions. The same goes for Pakistan. And in Bangladesh, an aggrieved person cannot even approach the court directly. And there's a particular legislation that I'd like to point out in India, which is a 2021 legislation for Delhi NCR, which is the pollution hub of the country right now and in the past years as well. The issue of stubble burning was completely done away with. It was not included as an offense to penalize for air pollution in a 2021 act. So that shows the position that, let alone a criminal law framework, the current framework is not even consistent because it forms a legal conundrum. And stubble burning is not penalized in a criminal sense, that we cannot get imprisonment for the same. If we look at the lacunae in the system, as I mentioned before, if we look at the transboundary aspect, there is more of an accusation diplomacy instead of a smog diplomacy. Politicians on both sides of the border, they hurl accusations at each other. And when there was a smog crisis in 2024 as well, the only argument was that the winds cause smoke from Indian side of the border to Pakistan and vice versa. And the same goes for the smog crisis in Dhaka. The blame was in Pakistan. And the farmers at this point, they are completely evading stubble burning detection by changing the timings, and they do not get the incentives or sensitization which is promised to them. So, if it is assumed that a criminal law framework is in place, how is it going to function? Is it going to function at all? If ecocide is considered and stubble burning is considered a part of ecocide itself, India and Pakistan are not signatories of the Rome Statute in the first place. And if in South Asia itself a climate change law is introduced for stubble burning, the forum is not clear because SARC itself is a dominant organization. So far, since 2016, there has not been a single conference. So the premise of my paper: why does criminal liability for stubble burning fail? When I said that criminal law should be inculcated, but even that is not possible at an international level. The reason is that farmer himself is the first victim of air pollution in the country.
In order to establish a criminal liability at an international level, there is neither mens rea on his part, there is not a deliberate intention to harm the environment. Secondly, there is no jurisdiction, and there is no recognition of the crime of stubble burning itself. So, how is it possible that at an international level a farmer can be declared a criminal in the first place? I'd just like to conclude with a few suggestions. Internationally, there cannot be a criminal law framework as yet. However, there can be a collaboration, there can be a treaty in place, there can be an annual meeting like the Conference of Parties held every year. It can be backed by the United Nations Environment Programme and the World Health Organization to assess all the standards. And at a national level, there can be a definite integration of criminal law. For criminal law, either there can be an amendment in the present provisions, or a new separate legislation can be introduced altogether. This can be in line with what the Honorable Supreme Court of India said recently in September 2025, that in order to create a deterrent effect, it is important that a separate legislation is established for stubble burning, and a trans-boundary dialogue is initiated with Pakistan and the entire Indo-Gangetic Plain, so that just a few selective imprisonments can also create a deterrent effect, because the current policies are neither very effective nor being implemented. However, at the international level also, since my theme for the conference was climate change law and global climate governance, if if the situation is not improved, we will have to resort to a criminal law framework in the ICC itself, because the question is, the farmer is a victim, but for how long? For how long will he be able to compromise on the environment factor to make his own living? That's it. Thank you.
Okay, my two suggestions for you participant to look into it. There are a number of countries who are currently working on their specific domestic provisions pertaining to the subject which you are just presented. You would try to look into some of the laws of Korea. You will try to look into some of the laws of China. You will see that they are having number of things. Even Japan are doing good. Talking about the Europe, you can look into the European Commission's some of the laws and legislations that well drafted in that thing. So what you can proceed for me, it's like try to come up with a comparative study rather than blindly telling that this need to be done, this need to be happen. So there are laws, try to assess those legislations and the policies, what are their gaps. So that's my
Yes,
suggestion. So
yes, sir.
like
Actually, yes, sir. Yes, sir.
okay, so there is also one question Secretary ma'am would be asking to you. Yeah.
I had only one question from you. Your presentation argues for stronger criminal action.
Yes.
So, how would you balance criminal liability with the fact that many farmers may lack affordable alternatives to burning crop residue?
Yes, ma'am, absolutely. My premise began with the fact that there must be criminal law in action. However, as I mentioned in this particular slide, a farmer is not even able to pay fines, let alone bear the burden of imprisonment. Therefore, the suggestion that I introduced in my last slide is in line with what the Honorable Supreme Court of India also said, that in order to create a deterrent effect, if the stubble burning is intentional and if it is habitual, that is when this criminal law framework should be inculcated. Not blindly, because a farmer, as I mentioned, is himself a victim. He is the first one who bears the consequences of air pollution, and then comes the other citizens. Therefore, in order to balance, intention as well as habit must be taken into consideration.
Okay, thank you for your presentation.
Thank you.
All right. I would like to call upon Mr. Vikas Kabir for the presentation.
Yes, ma'am. Am I audible, ma'am?
Yes.
Okay. I'm switching over to my PPT.
A small note to all the participants. We are exceeding up the time, so kindly keep your PPT ready. We can't provide extra time for loading this PPT. Yes, you can go
Okay.
ahead.
Okay, sir. So is my PPT visible?
Yes.
Okay. So good morning, everyone. I am Vikas Kabir, Assistant Professor, School of Law, MVN University, Palwal. Today, I am pleased to present my research paper titled India's Ethanol Blending Program: A Critical Analysis of Sustainability, Environmental Governance, and Public Policy. This research examines whether India's transition towards ethanol blended petrol can simultaneously achieve energy security, environmental sustainability, and inclusive economic development. So, India is confronted with two interconnected challenges: growing energy demand and climate change. The transportation sector remains heavily dependent on petroleum, while India's dependence on imported crude oil creates concern relating to energy security, foreign exchange, expenditure, and environmental sustainability. Renewable transport fuels such as ethanol therefore provides an opportunity to reduce dependence on conventional fossil fuels. However, the central question of the research is not simply whether ethanol is renewable, but whether the entire ethanol blending system is sustainable. In other words, we must examine its environmental, economic, and social consequences together. India's ethanol blending journey has evolved significantly. The program began with early initiatives in 2001, followed by the formal ethanol blending petrol program in 2003. The National Policy on Biofuels 2018 provides a comprehensive policy framework, and the 2022 amendment further accelerated India's ethanol objectives. Most importantly, the target of achieving 20% ethanol blending, or E20, was advanced from 2030 to ethanol supply year 2025-2026. This demonstrates the increasing importance of ethanol within India's energy and climate policy framework. So these are my research questions. Number one, what extent the ethanol blending program contribute to sustainable development and environmental protection? Second, what are the strength and limitation of India's existing legal and policy framework? And third, what governance reforms are necessary for an environmental, sustainable, and socially inclusive implementation? Methodology basically adopts a doctrinal and qualitative approach. So coming towards India's legal and institutional framework, so India's ethanol policy operates within a broader constitutional and environmental framework. Article 21, through judicial interpretation, supports the right to clean and a healthy environment, while Article 48A and 51A G establish constitutional commitments towards environmental protection. The policy framework is primarily supported by National Policy on Biofuels 2018 and the EBP program and subsequent amendments. Several institutions are involved, including the Ministry of Petroleum and Natural Gas, Ministry of New and Renewable Energy, Niti Aayog, oil marketing companies, state governments, and pollution control boards. Therefore, ethanol governance is inherently multi-institutional and multi-level. Sustainability benefits. The research identifies three broad categories of benefit. First, environmental benefits. Ethanol can contribute to lower fossil fuel consumption and greenhouse gas emissions, while agriculture residues can support a circular bioeconomy. Second, economic benefit. Ethanol creates additional markets for agriculture commodities, supports the sugar industries, creates employment, and contributes to energy security. Third, social benefits. The program has potential to promote rural development, farmer welfare, and green employment opportunities. Thus, and ethanol can potentially connect climate policy with agriculture and rural development policy. The sustainability paradox. But this thing brings us to the central argument of the paper. Higher blending does not necessarily mean higher sustainability. Ethanol production can create environmental pressure relating to water consumption, land use, food security, feedstock, sustainability, and industrial waste. Therefore, if India measures success only by percentage of ethanol blended with petrol, it may overlook the environmental costs associated with producing that ethanol. The sustainability assessment must therefore consider the entire life cycle of ethanol from feedstock cultivation to production, transportation, blending, and final consumption. The research identifies several governance and challenges. These includes weak monitoring, compliance issue, water stress, fragmented institutional responsibilities, and center-state coordination problems. Another major issue is data transparency. Information regarding feedstock composition, water consumption, life cycle emissions, and environmental compliance should be more accessible for meaningful evaluation. Finally, affected communities should have opportunities for public participation in environmental decision making. Therefore, the success of ethanol policy depends not merely upon policy targets but upon the quality of
Participant, can you come to your conclusion? You had exceeded the time.
Okay, sir. Okay. So to conclude, India's ethanol blending program presents an important opportunity to simultaneously pursue energy security, climate action, and rural economy development. However, its long-term success depends upon maintaining a balance between energy security, environment sustainability, and economic development. The central argument is therefore India's ethanol blending program should evolve beyond an energy policy into an integrated model of sustainable environmental governance. And this leads to the fundamental question: can India achieve energy transition without creating new environmental and social vulnerabilities? The answer depends upon how effectively we integrate sustainability into the governance of India's biofuels transitions. Thank you very much for your time and attention.
Okay, participant, I don't have any question for you, but there is a suggestion. Specifically,
Yes.
when we look into the justified questions asked by researchers and scholars across the world, whenever these kind of mechanisms are being comes from the government, which is in one way environmental friendly, coming up with a substitute as a biofuel, but again in the other hand, like the production itself, it's not too friendly. So my
Right.
suggestion is you should look into the aspect how the European countries has taken those steps, how they researched upon these factors, specifically the cost profit analysis has to be done, but pertaining to your paper, like you can't
Right.
blindly say that it is causing more harm than good. You have to prove it in your particular research. So that's my suggestion to you. Come up with a analysis, taken up reference from the European Commission's number of studies. You can take up reference from United Nations Environment Programs research also. It has done it on this subject. So that's the suggestion. Thank you for your
Okay, sir.
presentation.
Thank you, sir.
All right. Now I invite Ms. Yukti Chaudhary and Mun Mishra for their presentation.
Good morning, everyone. Is my screen visible?
Yes.
Good morning, everyone. So the presentation that we have today is on the topic bridging the protection gap for climate-induced displacement towards a regional immigration framework for South Asia. The methodology that we have used here is just a minute. I'm sorry. The methodology that we have used here is doctrinal and comparative legal research. And the primary research question that we are trying to answer is how can immigration law function as a complementary protection regime for climate-induced displacement? When we are talking about climate-induced displacement, I think it is important to understand that there are certain sudden onset events and certain slow onset events that occur due to climate change, which cause movement. Now, this movement can be either voluntary or involuntary in nature. When the movement is not voluntary, then we address it as climate-induced displacement. When we are talking about the terms climate-induced displacement and climate migration, I would like to just point it out here that in our research paper, we have synonymously used these terms, although identifying or at least acknowledging that there is a difference between the two terms. The protection gap, when we were analyzing the gaps that are there in the legal system, so we have divided it into international law, regional, and domestic frameworks. When we looked at international framework, we have looked at it from the point of view of human rights law, refugee law, and environmental law. When we looked at all these three laws, we found that even though these laws in some way, form, or manner provide certain protection, but the protection is either not expansive or comprehensive in nature, or the threshold, for example, the protection that is provided under human rights is as per right to life. The protection threshold is very high, as we had seen it in the case of Titiota versus State of New Zealand. If we talk about environmental law, it is just a soft law that is there in place. However, there are no specific legal status that has been provided or no binding protection rights that have been given to these people. Then, when we talk about South Asia, we have taken South Asia as a whole because it is a climate hotspot, and we are home to nearly 1/4 of the world's population. We have Hindu Kush Himalayas as well as coastal deltaic exposures, which makes us more prone and more vulnerable to these climate changes and the impacts that it has. Then, when we were looking at regional and institutional frameworks, we found that there are primarily three regional frameworks or mechanisms that deal with migration. The first one is SARC. SARC deals with climate change and disaster management, but has not yet expressly recognized either climate migrants or climate-induced displacement. When we're talking about BIMSTEC, we looked into it, and there is certain amount of work that has taken place, but it is more focused on early warning and emergency responses. Colombo Press, on the other hand, is more focused on the labor migration and overseas employment. And also, additionally, the 8 countries that we have dealt with are not there in Colombo Press as a whole. So it just has 6 of the 8 countries that we have. While looking at domestic and legal institutional frameworks, as you can see it in this slide, I'm not going to go into details of it all, but what we found in common was that in certain states like Bangladesh and Sri Lanka, there are certain policy protection that has been given, policy concerns that have been raised with regards to the climate change and climate change migrants. However, there is no legal protection as such, which has yet been provided in either of these countries as such, which covers climate displaced people in general as a whole. So what we have tried to propose, what we have tried to propose here is that we are wanting to use immigration governance as a complementary regime or as a complementary source of providing them some sort of protection. So why immigration governance? Because it has certain components to it. The first one is admissions and visas. We see that there are visas that are there in place, which are dealing with humanitarian visas and emergency visas. And we have also seen in recent times that Australia had provided certain special climate visa that was given to the citizens of Tuvalu, a state which is also very prone or vulnerable to the climate change. Then legal status and documentation. We have also seen during the time of Russia-Ukraine war, certain Ukrainian nationals were given temporary protection by the state of United States of America. Then humanitarian protection and family unity is a principle that is followed under the immigration governance. And there are also certain procedural safeguards which are to be there in case one uses this kind of framework. The framework that we have provided, we have just given a skeleton of it. I'll just go through it one by one. First of all, we suggest that all the 8 states would adapt a shared definition of climate-induced migration, displacement, and planned relocation so that certain recognition is given to them. Secondly, there would be a specialized determination wing to assess whether a person qualifies as climate displaced. Thirdly, this would operate through a common regional wing with membership proportionate to each state's population. Fourthly, recognized climate displaced persons would receive a special temporary visa. So we are not wanting for them to settle down there permanently, but only provide a special temporary visa, allowing protection for as long as the visa period continues. Fifthly, we are also not wanting the obligation to be there on, or the burden to be there on one state or the other states as such. However, we would therefore want the country of origin to work itself in such a manner that it makes itself habitable again within the specified period of visa, temporary visa that is given. Sixthly,
Participant, you can come to
we
the conclusion.
suggest, so this is the conclusion itself. Fifthly, we suggest that the Sixthly, we suggest that the basic human rights and livelihood support continue to be provided. Then we also suggest that there can be one regional oversight committee that is formed, which will have biannual reviews, which will also address the concerns of border safety and demographic concerns, because we understand these are the concerns when of the destination states when they are taking in immigrants. And lastly, we also suggest that certain SAFTA-linked sanctions can be there in place so that all the states contribute and work together uh, in unison. The conclusion that I just want to offer is that instead of waiting, we understand that there are legal gaps. We also understand that South Asia is a very vulnerable area in general, and the existing frameworks that we have are not enough. But why wait for the first world countries to come forward and help us when we can have a solution, at least temporary in nature, for the South Asian states itself? So it is a South Asian solution led by South Asian states to a problem that is global but more vulnerable. The states that are more vulnerable to it are the South Asian nations. Thank you, sir. Thank you.
Okay, thank you, participant. We don't have any question for you. Thank you.
Thank you.
All right, moving ahead, we have Miss Gauri Agarwal.
Good morning, ma'am. Good morning. I'm here. I'm just sharing my screen.
Yes.
Is it visible?
No.
Good morning, everyone. Chances are some of you on this call are wearing something right now with a tag that says sustainable, eco-friendly, or conscious. And statistically, there's a very real chance that that claim is exaggerated, unverified, or simply untrue. That gap between the label and the truth is exactly what we are here to talk about. I'm Advocate Gauri Agarwal, presenting with Dr. Anumeha Sahai on embedding circular economy principles into corporate governance, and why governance, not marketing, might be the only real cure for greenwashing in fashion. So first, before moving forward, we'll just have a look through three quick definitions. Circular economy means designing out waste and reusing materials. Corporate governance means what actually drives a board's decisions, not its press releases. Greenwashing means looking sustainable without being sustainable. Here's the uncomfortable truth. Fashion loves to talk green. Looking past the marketing, 2.5 billion tons of textile waste is in the EU alone every year. 90% of raw materials extracted worldwide are never reused. Yet, a circular economy could unlock $4.5 trillion in value by 2030. The money is there, the waste is there. Our question: can governance make circularity real, or does it just get rebranded? Circular economy isn't one idea. It's three, working together as a loop, not a line. One, eliminate waste and pollution at the design stage, not after. Two, circulate what already exists, repair it, reuse it, rent it, instead of just replacing it. Three, regenerate nature itself, not just avoid harming it. A closed loop, not a straight line straight to a landfill. So, where does governance fit in? A 2023 research found stakeholder engagement, sustainability reporting, dedicated environmental teams directly drive CE adoption. Board CSR committees, ESG linked pay, and UN Global Compact status don't drive it directly, but they legitimize and reinforce it. The scaffolding real circularity needs to stand on. Now take that scaffolding away, and here's what you get instead. Vague claims, eco-friendly with zero evidence behind it, self-made labels nobody audits, selective disclosure, that is organic cotton on the label and silence on the emissions, and carbon offsets used to buy a clean conscious instead of actually cutting the emissions. Four different ways to look green without being green. This isn't theoretical. It's happening at a scale right in our own backyard. H&M, Shein, and Allbirds are major players in South Asian fashion too. Bangladesh anchors most of their production, and India is among their fastest growing markets. So these case studies aren't distant, they are ours. H&M, most of us on this call right now must be wearing it. H&M's conscious collection, 96% of its green claims were unsubstantiated, while it launched 3,000 new styles per month. Shein's Evolution was fined €1 million by Italian regulators in 2025 for deceptive claims, even as it churned out more than 3 lakh new designs that year. Only 6% of them were recycled. Even Allbirds, the poster child of sustainable footwear, faced a lawsuit in 2022 in the US over a carbon footprint claim that omitted transport and supply chain emissions. 3 brands active right in our region, one identical pattern. Consumers notice too. Perceived greenwashing raises environmental concern, but that doesn't always turn into circular buying. Often it does the opposite. Trust erodes, and so does the will to engage at all. Greenwashing doesn't just mislead one customer, it poisons the well for every brand actually trying to do this right. So, what actually works? 4 boardroom fixes: dedicated board level CE oversight, mandatory reporting through global standards like GRI, and climate disclosure framework investors already use, independent third party audits, and executive pay tied to real, measurable circularity targets, not just vague promises. Beyond the boardroom, blockchain and Internet of Things traceability to verify claims product by product, alignment with regulations like the EU Green Deal, making brands accountable even after you are done with a garment, transparent, evidence based communication, and industry collaboration through bodies like the Sustainable Apparel Coalition. Put simply, verify, don't just wow. Governance, not marketing, delivers real circularity. Sustainability in a press release is fragile. Sustainability in a boardroom's key performance indicators, its actual targets, audits, and incentives, it is structural. And for economies across South Asia still writing their environmental governance rulebook, the very brands and markets we just talked through, this isn't just an academic finding, it's a blueprint. Regulators, boards, researchers, and yes, everyone on this call, you and I, are the ones who close that gap between the label and the truth, not by asking brands to promise more, but by asking them together to prove it. Thank you. Happy to take your questions.
Okay,
Are
we
there any
don't have any
questions for me?
question. We don't have any question for you, participants. Thank you.
Thank you, sir. Thank you.
All right. I would like to call upon Dr. Sonali for their presentation.
Hello.
Yes.
Yeah.
Dr. Sonali,
Please
you are
turn
not.
on your camera.
Just a minute. Am I audible?
Yes.
Okay. From where I should start my video?
Yes, it's
Yes,
visible.
it's visible.
You can start with your presentation.
Actually, I can't see the PPT right now. Okay, okay. Good afternoon, all. This is Dr. Sonali Wagmode, a pediatric dentist. We'll be talking about towards sustainable pediatric dentistry in India, a policy framework for green and climate resilient oral health care.
Participant,
Under the theme,
your slide presentation slide is not visible. It's just your screen is visible.
uh,
You,
is it
you had not.
visible?
No, you had not provided permission to your whole device. It's just one of your screen tab. It is visible to us.
Uh, Actually,
You cancel it
yeah,
and to try
it's
to reshare it again.
okay. I should stop sharing and then I'll start again.
Share up the whole screen, whole device.
Share screen, entire screen,
Huh,
right?
entire screen.
Okay. Is it visible now?
Yes, you can
Yes.
proceed with your presentation.
Okay. So, can we provide excellent oral health care to children without compromising the health of our planet? So, climate change is a health issue for people in the 21st century. Since increasing temperatures, poor air quality, more extreme weather, less water, and deteriorating life, so having the negative effect on the people's health, particularly that of the children. So here we can see in 2021, Mark et al. Showed that the climate change is causing distress, anger, and negative emotions in thousands of children and young people worldwide. Also, the UNICEF reported that children are particularly vulnerable to the effects of climate change. In the right side, we can see total annual carbon footprint of dental services in England in 2013-14 showed that there are various factors in dentistry are contributing for the climate change. Healthcare systems worldwide are responsible for producing significant amount of greenhouse gases. In that, dentistry is also contributing to climate change by using large amount of electricity, water, generating waste, using plastic and employing chemicals. So in the past, dental care systems have only keeping eye on the patient's safety, curing illness, creating more brighter smiles. But as concern of climate change has increased, there is need for the desire to create a eco-friendly and sustainable dental care. So FDI, World Dental Federation, has produced a policy statement on the sustainability in dentistry to encourage dentists to become more sustainable without compromising patient care. So prevention is a more sustainable approach. So fluoride application, sealants, oral health education, dietary counseling, regular risk assessment are the various options. But what is the main question? So there is gap in the policy for sustainable pediatric oral health care. So we know how to prevent the dental caries, but is it actually sustainable? Are we actually talking about the eco-friendly dental practices? What is the role of pediatric dentists here? So we need a sustainable pediatric dentistry policy because there are various systems that shows us how to go sustainable, but there is no as such a policy which can be scrutiny that every dentist is eco-friendly, is sustainable. What are the laws? What are the cures for that? So yes, existing policies in the India are National Oral Health Program, Biomedical Waste Management, Plastic Waste Management, E-Waste Management. There are national action plans on climate change. While these policies promote environmental sustainability, but they do not address the clinical and managerial challenges specific to the pediatric oral health sector, targeted initiatives are required to promote the sustainable pediatric dentistry in India. Why a sustainable pediatric dentistry policy is crucial for India to protect oral health of child and overall well-being, reduce environmental footprint of dental practices. Now, the rationale for the Indian dental policies is to growing pediatric oral health care needs, preventive and minimal invasive dentistry. To focus policy will promote sustainability across education, research, clinical practice, and governance. So here is the main slide where it shows that we have sustainability in India, but that is only limited to the prevention. But what is the major problem is there that we need a policy imperative which will combine the rising concern about the climate change, growing healthcare waste, limited resources, also how to create a generation which will think about this from their first step. So this is a proposed policy framework. So it is an Indian Sustainable Pediatric Dentistry Policy Framework. There are 6 pillars of that: sustainable clinical practice, resource efficiency and environmental sustainability, infection prevention and biomedical waste management, education and capacity building, along with research and innovation, governance, leadership, and monitoring. So here we can see the conceptual model is that child-centered sustainable oral health care will be covered with education, research, monitoring, and clinical practice. So being a dental student, being a dental practitioner, and now an academician, I can see that in India we are just concerned about the oral health care, but that oral health has to be sustainable in all the aspects. So the key responsibilities will be towards the Ministry of Health and Family Welfare, National Dental Commission, Indian Dental Association, Indian Society of Periodontics and Preventive Dentistry, all the
Participant,
dental
you can
colleges.
conclude. You can conclude.
So there is a small roadmap from 2026 to 2035. So ultimate goal will be the greener dental practices for healthier children, communities, and planet. So climate change and environmental degradation are the urgent global concerns, and we should be saving smile, saving future. Thank you.
Okay, thank you, participant. We don't have any question for you. Thank you.
All right. Now I invite Miss Khushi Pawar for the presentation.
Good afternoon. Are we perfectly audible and visible?
Yes.
Is the presentation visible, ma'am?
Yes.
Okay. Good afternoon, sir. I am Khushi Pawar, and today, along with my co-author Shivam Goyal, I'll be presenting our research titled Nature-Based Solutions or Nature-Based Justice, Embedding Equity and Accountability in South Asia's Climate Adaptation Program. So, at the very heart of our research paper lies this very simple question. When we talk about climate solutions, how exactly are we measuring its success? Are we only measuring the number of trees planted, the amount of carbon sequestered, or the area of forest restored? If yes is the answer to this question, we are not doing justice with the concept of NBS. When we talk about South Asia as a region, it is particularly vulnerable to all sorts of climate challenges, such as floods, heat waves, coastal degradation, biodiversity loss, etc. And to tackle this problem, the government has increasingly started moving towards adapting NBS as a solution to it. So, but again, the question is ecological restoration enough to measure the success of NBS implementation? Why are we not looking at the questions such as who benefits, who bears the cost, who participates, and who is accountable for the same? So, this brings us to our research question, that is, how can South Asian countries design NBS framework in such a way that it ensures local climate justice, protect community rights, and recognize the ecocentric rights of nature? And in the similar manner, our study seeks to examine NBS governance in 4 jurisdictions, namely India, Bangladesh, Pakistan, and Nepal, then evaluate NBS through 4 dimensions of justice, identify the governance gaps, assess assess regional cooperation and alignment with global commitments, and lastly, develop a rights-based nature based framework for the same. Our research is primarily the methodology that we have adopted is primarily comparative and qualitative study, wherein case studies from these jurisdictions have been analyzed and we have tried reaching a solution. So now when we talk about nature-based solutions, we are essentially looking at from a very ecocentric lens. But when we shift this perspective towards nature-based justice, we are also including the justice dimensions, such as distribution, participation, accountability, and ecological integrity. This shift is the need of the hour. Now further, my co-author will be explaining the 4 case studies.
Now, as we have explained about the nature-based solution, there are the 4 countries, major countries in South Asia, which have been case studies have been given. India and Pakistan have the similar case study of mangrove trees plantation. India is at Gujarat's coast, and Pakistan has Indus Delta region. In Bangladesh, it's a coastal afforestation of 9,650 hectares, and Nepal it has community forestry. All across all the 4 countries, the ecological gains are measurable, but the justice outcome and these policies which are formed by the government are consistently not secured enough, which lead to uneven governances. Like in India, it's fragmented implementation and insecure community rights. In Bangladesh, it's weak benefit sharing and the limited community ownership. In Pakistan, it's limited public monitoring and accountability. And in Nepal, it is facing elite capture and unequal participation. If I may rephrase it in a timeline, there are policies formed by these 4 South Asian countries, and fragmented institutions are looking for these policies, but there is weak monitoring and uneven community participation across the countries, which lead to justice and accountability gap, which is characterized into 4 major categories. It is first distribution, second the participation of the communities, third the accountability of the government who formed these policies, and fourth is ecological integrity, which has been addressed in the research. And the central finding is that intervention can be ecologically successful, but there is no justice which has been successful enough.
So our research also finds a very critical gap, that is in when we talk about South Asia as a region, we have various institutions such as SARC and BIMSTEC. Their potential remains very underutilized when it comes to solving the climate issues. The South Asian countries share similar climate commitments. They share similar climate problems. So why don't we come together and utilize the potential of these regional organizations? Now we come to the very innovative part of our research that we have brought to the table. That is the NBJ accountability framework in terms of 4R. The 4R represents rights, That means these communities should be identified and their rights should be preserved. Then secondly, representation. That means giving them a voice right from the very beginning of the project till the very end. Then responsibility in terms of an NBS justice scorecard, which will have 3 dimensions, namely ecological, social, and governance. And this will be publicly available. And mandatory dedicated institutions will be provided the responsibility. Then remedy, which means the grievance redressal mechanisms need to be made stronger. Now, an expansion of this framework is the NBJ justice test, wherein these 6 questions need to be mandatorily answered before qualifying a project as a real justice-oriented project. So we end our presentation by this quote that in order to get a restored ecosystem in its true sense, we need to take into account the interests of both nature and communities. Thank you, and the floor is now open for questions.
Okay, thank you, participant. The panel has no question for you.
Thank you, sir.
Now I would like to call upon Mr. Darshan Desai for the presentation.
Yeah, good morning. First of all, I and my co-author, Dr. Vandana, we thank you for this opportunity. Essentially, this thank you is more. The reason for this is that the story of this Vishwamitri movement, the story of this movement needs to be told. And that's what we think, that it's critical that the story is known. Okay, now for my paper. Is it visible?
No, it's not visible, Mr. Desai.
Yeah, excellent. Is it visible now? Is it
No,
visible now?
It's not visible. Mr. Desai, if it takes time, we can call you after one participant, if it is fine.
Yeah, please do so.
Okay.
I'm very sorry about this. I was ready. Okay. I thought I'm ready.
All right. Moving ahead, I invite Miss Aparna.
As participant, please share your presentation.
Is it visible?
Yes. The screen is visible. Yes, you can start with your presentation.
Okay. So, good morning, the delegates and fellow researchers. So, directly going into my topic is climate-induced disease burden, strengthening public health law in South Asia. So, the basic argument of the paper is that the climate change is no longer only an environmental issue, but environment issue. It is like daily as changing the environment. So it is increasing because a public health issue and therefore it requires a legal response. So my paper examines whether our existing public health laws are capable of dealing with these emerging health risks or not. So if you check in this slide itself, so why did I choose South Asia? If I need to answer, because the region combines a very large population with high population density, rapid urbanization, and pressure on the health kits infrastructure that we see comparing with the Western culture. So here, climate change is changing the disease environment. So whatever changing rainfall or temperature patterns that we are seeing these days, These can increase the vector-borne diseases such as basic dengue, malaria, or while floods and water contamination increased waterborne diseases. At the same time, extreme heat creates cardiovascular and respiratory stress, and drought can contribute to food insecurity and malnutrition. So, the problem here is not one particular disease, but climate change is changing the conditions under which these several diseases occur. And this is where I identify a governance deficit where the health risks are increasing, but our legal preparedness remains largely reactive. So, climate change is changing the conditions under which these diseases occur. Now, if you look, how effectively can current public health laws and climate governance in South Asia respond to climate-induced health risk? Here, my central research question is whether whatever existing public health laws that are there and climate governance mechanisms that are there in South Asia are actually capable of responding to these particular risks. And if not, what are the legal reforms that are required here? So I have used a normal doctrinal and comparative approach. So I examine constitutional provisions, public health legislations, and the environmental law and the international instruments. So particularly, I took India, Bangladesh, Nepal, and Sri Lanka. So now, if you look into the evolving health drivers, what are there? So there are three important pathways through which this climate change is affecting the health. So I was giving three important examples. The first one is the vector shifts. So whenever there is a temperature and rainfall conditions change, usually the vectors, breeding and the transmission patterns can also change, increasing the risks from diseases that we are seeing regularly. The second is the water contamination that we are seeing, the floods situations that we are seeing, and the coastal saline intrusion. These particular can affect the access to the sea water and increase waterborne diseases. Third is extreme thermal stress. So these heat waves particularly affect people who work outdoors. So those people, we usually see the agriculture workers, where most of the Indians are involved in the agriculture work, and construction workers, increasing risks of the heat strokes, dehydration. So several, not only the diseases that we see with regularly, the cardiovascular and renal problems are also increasing because of this extreme thermal stress. So climate change is effectively becoming a disease multiplier. So next, if you see the extreme heat mortality, so I have specifically highlighted this extreme heat because it demonstrates the shift from an environmental hazard to a direct health emergency. This is something we are observing present right now because of the El Nino situation, that is we are looking entire world, especially in the South Asian countries. So heat waves do not affect everyone equally. These outdoor workers and the low income communities, children and older
Participant,
populations
you can move
are.
to the solutions and recommendations.
Okay. So if I go directly into the suggestions and recommendations, so first thing I want to propose here is a legal reform roadmap which is necessary. So the first is, there are four phases I want to recommend. The first phase is the legislation. So first we need modern public health legislations that expressly incorporates whatever climate adaptation duties that are there. So legislation change is very important. The second phase that I want to recommend is the coordination. So now there are separate sectors. Environmental is dealt by separate authorities. Health is dealt by separate authorities. So I want health and environmental authorities should not work separately, but there should be a statutory intersectoral coordination between the two, like linking both the environmental and health ministries. The third one I want to suggest is the surveillance. So the disease surveillance should incorporate climate information and early warning systems so that authorities can act before outbreaks occur. So taking COVID into example, we can't start working post the warning has river. So whatever surveillance that is there because of the earlier situations, we should start from the beginning and we should let it know to the people. The fourth recommendation I want to, the phase four was justice. So whoever vulnerable populations are there, finally these need enforceable protection, particularly workers exposed to extreme heat and communities facing disproportionate climate risks. So, to conclude, my paper argues that climate change is fundamentally changing the public health landscape of the South Asia, but our legal systems have not evolved at the same pace. So, the problem is therefore not simply that we need more healthcare facilities or better emergency response. We need to rethink the role of law itself here. So, public health law must move from the reaction to the prevention, and from whatever fragmented governance that we have to the coordination governance, in from general protection to the climate justice. So, most importantly, the disease surveillance needs to evolve into climate intelligence. That is my recommendation.
Okay, thank you for your presentation, participant. We don't have any question for you. Thank you.
Thank you.
All right. Next, we have Mr. Darshan Desai.
My screen now. Yeah, I hope everyone can see this now.
Yes.
So, like as I said, that we are very much thankful for this opportunity that this paper. It is important that this river movement is being talked about and it is being told to people. That's very important. Okay, coming to the paper. People's river movement and civic monitoring for urban resilience. Now, the two things, river movement and civic monitoring, both of them are intrinsically related to the larger goal of urban resilience. Okay, and why we are calling this movement as a template of sorts? There are three reasons for that. Why we are calling it a template of sorts. So the first is identifying the issue. It all began by identifying that a certain riverfront development project which was being introduced would adversely disrupt the already fractured ecosystem, and it was seen as a real estate project in the name of beautification. So that was the first thing that was done by this group of environmentalists and urban planners and concerned citizens who thought that it is, to identify the issue. That's the first thing which has been done here. Once it is done, there is a four-pronged strategy which was adopted, and which is a case study. Which itself is the strength of the case study. That first is this began with soft advocacy with the authorities. That how this riverfront development project might adversely affect the already bad river ecosystem. So the first was the advocacy with the authorities, and they made it instead of a simple agitation that we don't want all riverfront development is bad or something like that. They went with a very facts-based scientific evidence. So that was the first immediate thing that was done. But also realizing that this wasn't adequate, they also knocked the doors of the National Green Tribunal. Okay, once again, it was backed by huge evidence of what exactly is happening. This was possible because these individuals had already been working in silos for the development of the river. So they already had very strong evidence about what was wrong and how this particular project would adversely affect. Okay, so that was a thing. And while doing this, the third part of the four-pronged strategy was this continuous field monitoring of the implementation of NGT's orders and the constant flagging of unauthorized construction. Now, this was possible also because these kind of monitoring was already going on in different ways. Okay, and now it became very it became a kind of second nature for these people to keep on monitoring what's happening on the ground. And the fourth is simultaneously creating a citizen's narrative. Essentially, the sum total of the narrative is that they're trying to uh, uh, impress upon the people that the link between river and the city, is very critical, not only for the health of the river but also for the overall well-being of the city. So that was the fourth layer at which they was working. So this four pronged strategy, and as a result, the why we are calling it a template. So as a result, there's an uncanny kind of citizens mobilization happened. And you can see the strength of this four pronged strategy is that even after 10 years of the withdrawal of this Vishwamiti Riverfront Development Project, it has been 10 years of the withdrawal, but that strategy is still persisting. Okay. And the continuous effort, continuous monitoring, continuous raising of issues is continuing. And how did that happen? Because this VRDP movement brought together different groups who were already working for the river. At the same time, it also created a kind of a buzz and a kind of a narrative that the river is actually a part. I mean, the river is not separate from us. It's not that there is a river and there is a city. No. So they and this brought together a group called Concerned Citizens of Vadodara. And the beauty of this group is that it's not an organized group, it's not an organization, it's not an NGO. Okay, it's just a group of people who came together and they were called, who came to be called the Concerned Citizens of Vadodara. So that's the biggest strength of that. And it is because of this strength that the Human Rights Commission, Gujarat State Human Rights Commission, took cognizance of the issue, and it is now the Human Rights Commission is monitoring the revival and the rejuvenation work of the Vishwamiti River. And this is very unusual. I would not say this is the first time. I would not dare say this is the first time, but it is absolutely unusual that a Human Rights Commission should would be taking up these issues, and continuously monitoring. And the kind of committees the Human Rights Commission has formed have all people from Concerned Citizens of Vadodara. So these three main things are the reason why uh, we're calling it a template of sorts. And so, as I conclude, the biggest takeaway of this movement is that it created a kind of emotional reunion of the people of Vadodara with the river. That's a very unique thing. And as someone who is living in Baroda for the last 4 years, 5 years, I can see it actually happening. So I'm not claiming that the river has been rejuvenated and revived. But the work on it is going on, and there is a people's participation as this work happens. And this is precisely why we are calling it a template of sorts. Thank you very much. Any questions?
Okay. Thank you, Mr. Desai. We don't have any question for you. Thank you for your presentation.
I would like to call upon Mr. Tanmay Gaur for the presentation.
Participant, you are not audible and visible.
Yes, you can start.
Okay. Namaste, my name is Tanmay Gaur. I am a research scholar from Dehradun Uttarakhand University. So my topic is a policy to power the evaluating the Indian transition from decentralized clean energy to Sustainable Development Goal 7. So what is Sustainable Goal 7? I will try to uh, brief about it. It's like we have a solar. India is moving from traditional energy sector to a renewable energy sector. So we are moving from coal-based or diesel-based power generation units to renewable energy sources. So what is currently with renewable energy is related to Sustainable Development Goal 7. So mostly we see that there are larger power stations and high tensile wires that are going from states to cities to power the big villages, cities, and heavy homes. And so what is happening in today's time? There are solar panels, windmills, and small power generation units. So the houses get the electricity. So by government is decentralizing the power from basic. The what of basic was mm, the power was given to the houses from big power stations, but now the houses are getting powered from small um, solar panels, rooftop panels, solar irrigation pumps, and village mini grids. So all these are get their sanctions or their administrative or the execution is done from the Electricity Act 2003. So there are some good points of about Electricity Act 2003 and some points that are missing. The one is the licensing. There are also the small rooftop licenses are very easy to get, but the bigger ones are very difficult to get. One is the discoms, the power purchase that the government takes from the citizens who are making electricity more than the required, and that there is also some tariff grounds that the government is giving small subsidies to the people to make to start their own electricity panels and their solar farms. If we see today's time, there are electricity generated in every house through rooftop panels, but the current thing is distributed. The administrative powers are distributed between the state and the center power because the electricity powers, the electricity generations, and the distribution is covered in the concurrent list of the constitution. And because of this, the government, there is a bit disturbances and there are a big problems with the center and state authorities because of the solutions that are given by both the states and the center. Center gives some kind of suggestions, state gives some kind of suggestions, and because of this, there is no single layer uh, paper where we can write and see that they are getting on one such thing. The center and state, there are certain yojana that are being given by the states, center and the states. If you want the PM Kusum Yojana, Saubhagya Yojana, PM Surya Ghar Yojana, or National Solar Commission on Discom reforms that help the citizens to use solar panels in their homes for the power generations and cut down their electricity bills. If we see there are small problems with these uh, solar generation plants, one electric generation plants. One is the land acquisition. There are more land that is acquired by the government is the agricultural land, and infertile land
Participant,
is
you
to be
can
used.
do your recommendations and solutions.
Yes, sir. If we go from the for the recommendation and solution, there are few things that are required that uh, the state and center is required to come on the same plane. Second, there discom subsidies that are given to to the people should be future fixed. That in some states the discom subsidies are less, in some states they are high. Third, there are something that is required that the land acquisition that is taken by the government should be of unfertile land. And fourth, there is something that is required that the discoms, the discom networks, they are usually what the government do. Um, the electricity is directly given to the central electricity units, but it requires a smaller grade units which electricity should be transferred. And fifth, the carbon emissions must get lowered because of this, and the carbon credit should be given to the people and the states for from the directly international departments for the development of the nation. Thank you.
Okay. Thank you for your presentation, participant. The panel has no question for you. Thank you.
All right. Now I would like to call upon Ms. Sakshi Sharma for the presentation.
Am I visible, ma'am? And audible?
Yes.
Yes.
We can
Okay.
see.
Good morning, everyone, all the panelists. My topic is rise in e-waste due to digitization and its impact on health and environment. Okay. So as we have known that the world has becoming a digital, and India is also has come to the stage
Participant,
of.
keep your mic closed so that you
Okay,
can.
okay. Yes. Can you hear me right now, sir?
Yes, go
Yes.
ahead.
So yes, digital India and rapid digitization have accelerated the manufacture and the use of electronic gadgets. As we have seen, there's a lot of compilation that the world and the India as well is using the digital, but they don't know what the impacts it is creating in the environment. Like don't have the exactly that how to decompose or dispose this digital waste. So my paper is regarding this, that there are many laws and the rules have been made that how to you uh, sort out the digitization, the e-waste they are creating in the environment, and it has a great impact on the environment and the health of the people. Let's first understand what is e-waste. And e-waste refers to discarded electrical and electronic equipment and its components, and it includes the computers and mobile phones, and refrigerators, air
Participant,
conditioners.
you can skip this introductory session like things which
Okay,
is known to
okay,
everyone.
yes, okay, okay. So the global e-waste problem that has been seen, the margin that 62 billion kgs has been already there, and along with that, the Indian regulatory framework that they have dealt with the Environmental Protection Act and the e-waste management rules of 2011, 16, and 22. The rules have been made, but there are still a gaps that is present in there. So I have highlighted all the gaps that are present in the regulations. That, for example, 2000 rule has a complex authorization, but it has a weak EPR. Like it's a producer responsibility that you also aware the people about how you can dispose the electronic waste. Okay, so this the responsibility is not only not for the producer but also the person who is selling the products. So as we move further, what are the impacts that it has resulted in the humans, that women are suffering from the miscarriages and low birth, and the children affects the impaired physical developments, and the environment also does reduce the soil quality, which is also affecting the agricultures in our uh, country. Then in conclusion and the way forward, I put that as we have like you are using a digital media platform, so we can use the help of AI to for the e-waste segregation and improve the digital tracking and compliance. As much as we can promote a durable products, so we can we can prolong the use of the devices, and to strengthen the awareness through the educational institutions, seminar, and public campaigns that we can conduct. So this is all from my side. Thank you, panelists.
Okay, participant, there are two suggestions for your paper. Your paper should include an analysis of the international policies and
Yes, yes, sir.
reports, which you had not included. So
Okay, okay,
try
sir.
to try to incorporate those, and also the second thing is try to include some of the case studies. Like there are case
Yes,
studies relating to e-waste, multiple case studies you can find. Even if you visit the United Nations Environment
yes, sir.
Programs.
Yes, sir. I have referred
Yes.
in my paper, sir. Thank you. I'll take that suggestion. In my paper, I have mentioned the comparison between the countries as well as the conventions that are used in the Basel conventions
All
and
right.
the Directive Europeans. Yes,
try
sir.
to
But I'll
try
take
to
it.
come
Yes,
up
sir.
with try to come up with a critical analysis. It's not just you had mentioned the things how they are working and what are the cost profit analysis the country are looking forward for any of the development or even with the e-waste management. All
Yeah,
right,
right.
thank you.
Okay,
Yeah.
okay. Thank you, sir.
Now I invite Ms. Achal Prasad for the presentation.
Hi, good afternoon. Is my screen seen?
Yes.
All right. Good afternoon, everyone. I'm Anshul, and I'll be presenting our paper, ICJ Advisory Opinion and its Obligation for the Global South, a case study of India, co-authored by Dr. Vidya and Jacob and me. The paper examines state obligations concerning climate change, particularly their implications for corporate accountability in India, following the International Court of Justice Advisory Opinion. Climate change is fundamentally a collective action problem. However, corporations remain major contributors to greenhouse gas emissions, which raises an important legal question. Who bears responsibility for regulating the emission? The ICJ advisory opinion provides an important answer. It clarifies that states have climate obligations arising not only from the UNFCCC Kyoto Protocol, and Paris Agreement, but also from customary international law, human rights, and other environmental regimes. To understand this development, it is first necessary to understand the international framework. The ICJ treated the Paris Agreement as part of a continuing international climate regime operating alongside UNFCCC and Kyoto Protocol. And the court rejected the argument that these treaties form a lex specialis regime excluding other international law. This broader framework becomes particularly significant for the Global South. The court reaffirmed common but differentiated responsibilities and respective capabilities, or CBDRRC. However, the opinion does not treat CBDRRC as an exemption from developing states. Rather, the degree of due diligence expected from each state depends upon its capabilities, resources, and national circumstances. This effectively places states on a continuum of responsibility. As the developing economies grow in capacity and emissions, their expected climate action may also increase, while developed states continue to bear greater responsibilities, particularly concerning finance, technology, and capacity building. However, the Global South cannot be treated as a homogeneous group. Its states occupy very different economic, geographical, and climate positions. Climate vulnerable states may demand stronger mitigation and financial assistance, while emerging economies may resist obligation being perceived as restricting development. India's abstention from the General Assembly resolution welcoming the advisory opinion illustrates this particular complexity. This brings me to India's position. India has consistently approached climate change through the principles of sustainability, equity, and CBDRRC. Before the ICJ, India emphasized that developing states retain sovereign rights over their natural resources and require sufficient policy space for poverty alleviation, energy access, and economic development. India therefore resisted interpreting international law as imposing specific obligations to phase out fossil fuels or fossil fuel subsidies. The question therefore becomes, how does this translate into Indian law? India already possesses a number of substantial domestic foundation for environmental protection, such as Article 21, Article 48A, and Article 48A and Article 51A Clause G. And the Supreme Court's environmental precedents are there as well, including MC Mehta's case, as well as MK Rajit Singh versus Union of India, which marked an important development by recognizing constitutional rights arising from climate change. This leads to the central issue of this paper, which is corporate accountability. The ICJ does not directly impose international obligation upon corporations. Instead, it places responsibilities upon states to regulate private actors whose activities contribute to climate harm. Article 21, the Environmental Protection Act, the Companies Act provide a foundation for corporate environmental responsibility in India. One mechanism through which India is attempting to operationalize climate responsibility is the Carbon Credit Trading Scheme. Established under the Energy Conservation Amendment Act 2022, the CCTS creates India's domestic carbon market. It combines compliance and offset mechanisms, particularly targeting emission-intensive sectors. Its significance extends beyond domestic regulation. It supports India's nationally determined contributions and potentially facilitates also cooperation with the Paris Agreement. However, the existence of a carbon market does not necessarily ensure effective decarbonization. The CCTS may face difficulties arising from relatively low carbon prices, limited technical awareness, and market uncertainty. The central problem, therefore, is not whether India has climate mechanisms, but whether these mechanisms are ambitious and integrated enough to change corporate behavior. This brings me to the central conclusion of my paper. India already possesses constitutional principles, environmental legislations, corporate governance mechanism, and carbon market frameworks capable of supporting climate action. The challenge is that these mechanisms operate largely in separate spaces. The ICJ advisory opinion provides an important opportunity to connect the state obligation and domestic climate policy. For India, this must occur while preserving the realities of development and poverty eradication. Thank you.
Okay, thank you, participants. The panel has no question for you. Thank you.
All right. Now I would like to call upon Ms. Karandeep Kaur for the presentation.
Good afternoon, everyone. Am I visible?
Yes.
Is my PPT visible as well?
Yes, it is. You can start.
So, yes, I'm Kirandeep Kaur. I have done the legislative analysis co-authored by Dr. Anand Pawar sir on linear model to circular sustainability in Indian biomedical waste management regulatory framework.
This paper determines that how India's biomedical waste management regulatory framework can be re-envisioned from the perspective of circular economy by not compromising the public health safety in India. The central proposition here it is that there is management of biomedical waste management in India, and second, that introduction of circular economy in healthcare sector. As we all know that waste management is also a resource, so circular economy embodies the principle that these resources can be put into circulation by reusing, remanufacturing, and recycling. And in the healthcare sector, we can achieve the zero waste goal in the healthcare sector. So the search question here is how to re-envision India's regulatory framework on biomedical waste management to include more regulations on circular sustainability rather than linear model without compromising the public health safety. With the growth in healthcare infrastructure in India, we are also seeing the increase in biomedical waste in India, and this biomedical waste prominently includes the single-use plastic in it, and because of this single-use plastic, we are leading to the end-of-the-pipe approach. This end-of-pipe approach means that we are most of the time we are utilizing more of the treatment facilities rather than we are disposing of or treating the waste at the generation point. So there is less circulation, which is leading to overuse of incineration methods, which is leading to the persistent organic pollutants emission like dioxins and furans, which are prohibited by Stockholm Convention of 2001. The Stockholm Convention is on persistent organic pollutants only. Biomedical Waste Management Rules 2016 is the exhaustive rules which are the main legislation in India, which is enacted under the umbrella legislation of Environment Protection Act 1986. It is this significant legislation which is covering all the treatment, disposal, and the segregation facilities at the generation point, and also giving the treatment technologies in it. So barcoding and color coding of biomedical waste and containers is there. Pre-treatment of laboratory waste at the point of generation is there. Total prohibition of phasing out of chlorinated plastic bags was also there, which was incorporated by 2019 amendment. And there is establishment of treatment plants within specified radius, that is 75 kilometers from every healthcare facility in India. There is mandatory installment of GPS tracking in the vehicular transporting in biomedical waste. Hence, circular economy is there in biomedical waste management rules. These biomedical waste management rules are significantly using all the linear model and circular economy hand by hand, but we need more of the circular economy principles to achieve the zero waste generation goal in healthcare and biomedical waste industry. These rules and these circular economy principles are appreciated by Indian Constitution and statutory structure. This is the golden triangle of environmental provisions in the Indian Constitution, that is Article 21, Right to Life, 48A DPSP, and 51 AG of the fundamental duties to protect the environment in India. The statutory foundation starts with 253, that is the plenary power under the Constitution of India, which provides that Indian Parliament can enact the laws based on the conventions and treaties, and under Environment Protection Act 1986, the waste specific rules, biomedical waste rules 2016 and plastic waste management rules 2016 were incorporated. The main part is the biomedical waste management rules are linear or circular. By giving the comparative analysis, by fixing putting all the rules in two models, that is linear model and circular economy model, we get to know that there are more provisions related to linear model and less provisions related to circular economy model. So to achieve the zero waste generation in the healthcare facilities, we need advanced technologies, inclusion of extended producer responsibility. There should be specific provisions related to training and awareness provisions. Waste hierarchy clauses should be there. Best practice learning from South Korea, Japan, and Sweden should be there, which are incorporating the best technologies and zero waste generation in biomedical waste industry. Less take, make, dispose, that is inclination towards the linear model, expanding the digital tracking and giving more incentives to the
healthcare facilities which are incorporating circular economy principles. The concluding part is that biomedical waste management rules 2016 provide a significant foundation of segregation, tracking, treatment, and safe disposal. But however, we need more circular economy regulatory model, and to that, so that we can expect the result, that is lower waste, lower treatment burden, greater resource recovery, which would lead to reduced environmental carbon footprint, stronger health, and climate resilience. Thank you.
Okay, thank you, participant. We don't have any question for you. Thank you.
All right. Moving ahead, I invite Aritra Jana to present.
Greetings to everyone. This is Aritra Jana, along with my co-author, Professor Dr. Jitin Jagadanandan. We are presenting paper on the topic Invasive Alien Species Conundrum in India, assessing the legal framework for advancing SDG 15. So, in light of this, the major challenge that we are posing over here, that our paper talks about, is the invasive alien species in India and across the globe. So, invasive alien species are such species when they are non native to an environment, and when they are introduced in a native environment, they erode the native regeneration and they take up their space and reduce their growth and affects the ecosystem. The annual losses that is incurred due to the IAS globally, it's USD 423 billion per year. And the recorded invasive alien species in India is 145 to 185, with reference to a new notification by the MOFCCA in June 26 that gave out that it has increased to 175 in the plant species and animals to 195. So, with reference to that, my paper talks about the linkage between SDG 15, that is life on land, in relation to IAS, that how IAS is essential to achieving SDG 15 targets, especially SDG 15.8, and alongside 15.8.1, which showcases the indicators. So, this is the international legal instruments, the historical development, how it came about. To propose, there are three major instruments. First one is 1992 Convention on Biological Diversity. It especially talks about this invasive alien species and wants the nations to draft legislation in order to curb it. Next, we come up to 2010 IG biodiversity targets. It also reiterates the provision of CBD. Next, the recent one is 2022 KMGBF target that talks about eradicating or controlling IAS by 2030. Now, coming down to Indian legal framework, what we have and what are the legal loopholes. So we have certain acts. The parent act is Environment Protection Act of 1986, but recently in 2022 amendment which was made to Wildlife Protection Act, it consists of section 62A, which talks about controlling of invasive alien species, but rather the jurisdiction, or rather the territorial eradication of IAS has been curbed in this. That is basically the challenge, because it talks about eradication of IAS in the protected areas and not globally or pan India. Coming to the challenges in the current legal framework, first is fragmented legal frameworks across all these acts. There is an absence of dedicated IAS specific legislation, which can be found in countries like Japan, or rather, we can say in the European Union, or there is another act of 2015 which talks about biosecurity measures in Australia. There is weak enforcement mechanisms and inadequate monitoring capacity. Also, there is limited public awareness with respect to the livelihoods or the people living in the villages, as well as stakeholders. So now coming to the major part, that is the SDG indicator 15.8.1 analysis. So to sum up, we see that on Asia Asia Pacific average, it is 61%, and the global average is 68%, as well as in India, it's 40%. So, how did we come up with this? We take up all the indicators one by one and we have analyzed. So, over here, we have marked first one is the policy existence, which is there, and with reference to them, most of them are not present. Among all the five, only two of them are present. That is how we calculated it to be 40 and not total 100. So, with reference to this, I would come up to my recommendation that would suggest that we need to enact a dedicated IAS legislation with clear definitions and penalties. We need a central IAS authority, with respect to which I would say that recently there is a notification which came in March 2026, which talked about the establishment of a IAS specific committee. There needs to be funding. We need to improve or promote public awareness, as well as stakeholder engagement for funding purposes is required, as well as with regards to institutional mechanisms, there has to be more prompt or prominent way of IAS management. That's all from my side. Thank you so much.
Okay. Thank you, participants. The panel has no question for you.
Thank you, sir.
All right. Now I would like to call upon Dr. Sandhya Sharma for the presentation.
Hello, is my screen sir visible?
Yes, you are not visible.
Just a minute, am I?
Yes.
Okay, thank you so much. Can I start?
Yes.
Okay. Good morning, good afternoon, everyone. Respected chairperson, distinguished delegates, academicians, and fellow researchers. I, Dr. Sandhya Sharma, will going to present on the title. On the title Environmental Liabilities in Corporate Insolvency Towards Sustainable Insolvency Governance under IBC 2016. So to start with a very brief introduction, IBC from 2016, IBC have shifted from the piecemeal legislation and it was data-centric approach to the creditor recovery to a time-bound debtors rehabilitative regime. So on its own term, we have seen that IBC have been made a great shift. We can see its work through the number of cases which has been resolved, the number of recoveries which have been improved. But the core tool, the moratorium section under section 14, the clean slate doctrine under section 31, and the priority waterfall mechanism as mentioned under section 53, they are being built upon without reference to the environmental liabilities. So if we see Indian context, Indian law treat environmental liability as an absolute liability, and enterprise meaning thereby the enterprise must remedy the harm it has caused, regardless of the fact that it and this isn't diluted by any economic hardship which has been followed by a particular enterprise. Yes, under the IBC, the same obligation is treated as an ordinary and even extinguishable claim. So, there's a more structural loophole that that let the environmental cost pass into a public and future generation, while the polluting company is rescued with a legally sanctioned clean slate. Now, if I talk about the doctrinal foundations, the Indian court from the long held that polluter to a high standard. In the case of the MC Mehta, we have seen that, which arise from the oleum gas leak case. The Supreme Court held that the hazardous enterprise owe an absolute non-delegatable duty to compensate, regardless of the taken care whatever has been taken care by the enterprise. In the case of the Bichri case, the court again held that the polluter pay principle require bearing full cost of restoration, not just a compensation. Again, in the case of the Vellore Citizen case confirmed that the polluter pay principle and precautionary pay principle are the part of the environmental law. But to the surprise, we see that none of these cases, or none of the cases in the environmental law has been mapped onto the IBC, which is built upon entirely under crystallizing and discharging the claim within a fixed window. Now, if we see how IBC have marginalized these claims, so there are 3 points of failures. First is section 14, which talks about the moratorium. So whenever the corporate debtor went into a financial difficulty, and once the application has been admitted by the NCLT, it suspend all the suits against the corporate debtor, which includes the
Participant, your
NGT
slides
claims.
are not moving. Your slides are not moving.
I think it's
Start this slide moving. Yes, now it's moving. Yeah.
Should I start, sir?
Yes, yes.
Okay. So next we talk about the how the IBC actually marginalize these claims. So there are 3 points of failures. Firstly, section 14, which talks about the moratorium. Moratorium basically means the suspension of all the suits against a particular corporate debtor, and the suspension includes the NGT and civil claims for remediation during the entire CRP, corporate insolvency resolution process, with no mechanism ensuring that the ongoing harm get addressed meanwhile. Now, the second issue is that section 54, which talks about the waterfall mechanism, like hierarchy on the basis of which it is to be paid to the various stakeholders. So, waterfall gives environmental dues no distinct priority. Even they are treated as a ordinary operational debts, which are ranked behind the secured creditors, and typically recover very less amount or nothing, like a very or sometimes they'll receive nothing from the corporate pool, like the consolidated amount basically. And now the third and the most significant is the clean slate doctrine under section 31. The cases like SS Steel have confirmed that the resolution applicant can take over a fresh slate free from claim, not in the plan. So in the case of Ghansham Mishra, again, which has confirmed the SS Steel case, confirmed that this applies even to the government claims. So these decision carries a unexamined implication, and environmental liability is not being crystallized and not submitted within the
recommendations.
Okay, sir. Thank you. Okay. Now to finally to conclude and very briefly talk about the recommendation. Reconciling the IBC rescue mechanism objective with polluter pay principle doesn't require abandoning the time-bound resolution under the IBC. So my recommendation would be, first is to environmental due diligence should be mandatory component of the information memorandum prepared by the resolution applicant, which disclose all the known and reasonable foreseeable liability. Second is drawing upon the Red Water Framework, section 31 and 53, should distinguish environmental obligation genuinely reducible to a monetary claim from the ongoing regulatory obligations. And third would be the sustainable asset valuation should be built into the fair value and liquidation value assessment under the CIRP regulations, requiring the valuer to price in an unamended environmental liability, like the approach which is being followed by the EU. So lastly, to close the entire presentation, I would like to conclude that the IBC has succeeded on its own term, building a creditor rescuable system. But in silence on the environmental liability, it is neutral. Read together, like we have seen that section 14, 31, 228, 53. Let the polluter pay principle, a doctrine established by the Supreme Court, has repeatedly upheld. It's been defeated simply by the polluter's insolvency. So that's all from my side. Thank you.
Okay, participant, I have two things to tell you specifically pertaining to the suggestions. When we look into the IBC's objective, promoting the environment, that's very different to say that the promotion of environment, or like coming up with the environmental sustainability principles, it's not the basis of the IBC's guidelines, and that can be the major issue for which it has not come up with the mandative nature of those instruments. So my suggestions to your paper is to look into those countries. Specifically, there are Europe's numbers of nations where this type of directions are being mandated, where they had been working for more than, I'll not say a decade, like at least 7 to 8 years. So you should look into those countries, how they had changed, like after implementing those guidelines and directions, how they have changed, coming up with the post and pre studies, like pre guideline and post guideline studies of these countries, that will give a clear idea of your recommendation and suggestions. That's our yes.
Thank you, sir. I'll definitely take your recommendation into building upon this paper further.
Okay, thank you.
Thank you.
Moving ahead, I invite Ms. Shalini Sharma.
Am I audible? Ma'am, you're not
Yes.
audible, so am I audible?
Yes, you are audible.
Okay, I'll begin with my presentation. Good afternoon to the chair and everyone present here. So the topic for my presentation is greening the cities or displacing communities. Now, the paradox that lies when we talk about this issue is the modern cities are trying to become cleaner, better, safer under the United Nations Sustainable Development Goal. And the SDG goal that I'm specifically talking about is SDG 11, which talks about sustainable cities. They do this by building parks, smart cities, clean riverfront, and low carbon building. However, the cost that is again being incurred with respect to this is these green improvement make the surrounding neighborhood highly desirable, which basically drives up the property value, thereby displacing the people for whose protection and for whose benefit it was in fact made, leading to a term called as environmental gentrification. Because the people who were actually residing there, they're displaced now, the low income resident. Obviously, because of the greening and because of the smart city, the prices escalate and now they no longer can afford it. So the programs built to create sustainable cities frequently produce exclusionary ones, contradicting the SDG's pledge to leave no one behind. So this is the central issue that I'm dealing with respect to environmental gentrification. And I'm talking about, when we're talking about sustainable goals, we shouldn't only look at one SDG specifically when we're talking about anything. So it should be an integration of, if we're talking about sustainable cities and communities, it has to be integrated with SDG 10 and SDG 16 as well, wherein SDG 10 talks about reduced inequality. Sustainability has to be judged by who bears the cost and who reaps the benefit, as well as SDG 16, which talks about peace, justice, and strong institution. So it is a measure of process where an accountable institution where displacement can be contested before it occurs. So under this paper, I'm trying to say that SDG 11, 10, and 16 should be looked at as one integrated criterion for evaluating any green city or any green infrastructure program instead of looking at them in silos. Now, so the tripartite justice model that I'm talking about is, firstly, we cannot only look at distributive justice or only recognitional justice. We should ensure that there is distributive justice, that is, who has access to new green space, safer housing, and cleaner air, and who does not. We'll also have to look at procedural justice. Is the decision making and planning process open? Is it fair? And is it democratic for everyone? And again, recognitional justice, wherein we're talking about the concept of leave no one behind. So do we respect and value the lives, history, and identities of marginalized group, in fact? Otherwise, environmental gentrification is not only about unequal outcomes. A project can share benefit fairly, yet still the people whose voice should have been highlighted. I mean, when we talk about lived reality, their voices are not being prioritized, and it would lead to failure of the entire sustainable city project. Now, this I have highlighted through three examples. The first being the Ken Betwa, a very recent one wherein Chita Andolan is in fact going on in 2026. In this, the very famous project, it was built wherein India's first inter-river linking divert water from Ken to arid Betwa basin in order to ensure that there is water which is there for everybody. It has started with a sustainable goal. However, when we look at this 44,605 crore rupee project, we are seeing that the issue that is existing in this particular case is that it is displaced, in fact, 6,000 to 9,000 Forest area has in fact been submerged. It has been flooded. 1 million plus tree has been eradicated, and 22 village have been residents of 22 village have in fact been displaced due to this. Due to which people are doing Chita Andolan because they have not gotten the fair price for this as well. So even though these projects have been taken up saying that it is sustainable, but when we look at it only from an angle of SDG 11, it looks sustainable. But when we combine it with other SDG, we see that it is linked to inequitable distribution. Again, similar project of smart city and mission and greening linked eviction. It was again a major government initiative which was launched in 2015 and across several cities, Indore, Bhubaneswar, Delhi, Kochi, all of these poor communities have been forcibly evicted under the guise of beautifying the city, clearing water bodies and building green pathway. And as the figures show, 552 families have been evicted, 1,500 residents have been evicted in Dharamshala. 1 in 5 people have documented eviction nationally linked to environmental conservation project. Now, another example that I've taken is of Sabarmati riverfront development. Again, this has been guised as sustainable project, but when we look at the field study on relocation colonies report, it reports poor resettlement quality and migration back into informal settlement near the very riverfront families were moved from. So even though they were promised this, they are again pushed back to those slum areas. Nothing has happened. And the court order, I'm not going to read out all the court orders, obviously starting from Olga Tellis, which said that there has to be a checklist, but now that checklist is
Participant, you
just
can
being
move
used
to
to
the
evict people.
solutions.
But there has to be a proper process that
Participant,
should
you
be
can
followed
move
that
to the
was held in
solutions
Olga
and
Tellis, but which is
recommendations.
not happening. Also, when we talk about the Land Acquisition Rehabilitation Act of 2013, now people are being categorized as encroacher in order to ensure that they do not get compensation for being evicted from a particular place. So all of
I'm
these
sorry to
laws and all
interrupt.
of these case laws are not
Please
helping.
conclude your
So I'm
presentation.
saying that we have to reimagine this entire green growth through SDG when we are talking about a particular, in order to conclude my discussion, when we're talking about any sustainable city building, in order to avoid environmental gentrification, we'll have to see that we cannot solely in silos look at a particular SDG. We will have to integrate the 3 SDGs. So when we're talking about this, we'll have to see and we'll have to ensure that first and foremost, that SDG 11, SDG 10, and SDG 16, that is sustainable city, distributive justice, as well as procedural commitment are all integrated together. That will lead to closing the gap between environmental clearance and social impact assessment. It will end the administrative reclassification of long-term occupants as encroachers because this deprives them of the compensation as well. This will help build binding community participatory rehabilitation standard into every green project. Absent this, obviously this cannot happen. Thank you. That's all from my side.
Thank you, participant. We don't have any question from you. Thank you.
All right. Now I would like to call upon Miss
Ma'am,
Tanisha
I
and Miss
can't hear you.
Mokshi for
You're
their
not
presentation.
audible. I'm sorry. I'm not able to hear you.
Participants, your presentation is over. We don't have any question from you. Thank you. Yes, so go ahead, host. We can move with the next participant.
Yes, now we have Miss Tanisha and Miss Mokshi.
Hi, am I audible?
Yes.
Yeah, so could you please also have my co-presenter on here because she will be starting.
Yes.
And I've uploaded it, so just a second.
Am I audible?
Yes, you can start.
Thank you. Thank you. Good afternoon, everyone. I am Mokshi along with my co-author Tanisha. We are here to present our paper on how rising seas threaten South Asia's maritime borders. We begin with a very simple question. When the physical land we use to measure sea boundaries washes away, do our legal ocean right have to shrink with it? This is not a hypothetical question in South Asia anymore. Sagar Islands in Sundarban is a very useful example here. Its area declined from approximately 250.66 square kilometers in 1970 to 233.40 square kilometers in 2020. The core legal question that our paper addresses here is, does that physical change automatically change the maritime entitlement of the state? To answer that, we first need to separate two concepts under UN laws. First question comes from Article 121, Clause 3, which looks at a physical feature like a rock or a tiny island and asks, can this piece of land actually sustain human life or an economic life on its own? The second question comes from Article 5 and Article 7, which deals with the baseline. A baseline is a legal starting point from which our maritime zones are measured. Normally, these lines are tied to physical beach like low water mark, meaning that they are ambulatory. They shift inwards as the beach erodes. But if we force borders to move every time the beach shrinks, the countries will face the constant chaotic uncertainty over who owns the valuable fisheries, oils, and shipping routes. Our paper argues that we should not use one single rule to decide both the physical land status and the legal boundary status. Physical change should not mean the automatic legal change. This is where the paper asks more fundamental question. Does the UN clause actually require that? This brings me to the part third of our paper, which what does the law actually support? So the paper argues that the country they can legally freeze and preserve their existing sea boundaries so they don't shrink. It builds this case on three arguments. First is the main law, the law of the sea treaty, the UN clause, which was written back in 1982 when the people assumed that the coastlines they were stable, because the treaty says absolutely nothing about a duty to constantly update the boundaries. When the sea rise, the countries are legally allowed to keep them right as they were. The second argument is about International Law Commission's 2025 final report and the ICJ Advisory Opinion 2025, which similarly concludes that UN clause does not require state to update charts and geographical coordinates, showing that the established baseline and the outer limit merely because of the physical change caused by the climate-related sea level rise. Third argument, and the most important argument, is the climate fairness, which is the equity. The countries losing the land to rising seas, like the small island nation, they did the very least to cause this very global warming. If the international law takes away their ocean resources on top of flooding their land, it commits a very compound injustice. But there is one catch here. Freezing map lines protects our legal rights, but it does not solve the practical issue on the water. If an island goes completely underwater, how does the neighbor cooperatively share its fish, its energy? To explain that, to explain how we defeat the legal critic and how we make a practical hybrid model work in the real world, I'll now hand it over to my co-author, Tanisha.
Okay, hi. The proposal to preserve maritime limits faces three objections. First, the treaty text objection, where baselines traditionally move with the coastline. So if the coast retreats, then the maritime zones are expected to retreat as well. Second is the ghost zone objection, that a fixed baseline may leave water between the new coast and the old legal baseline, which can be treated as internal waters, which can cause confusion and affect navigation and cause confusion regarding innocent passage. Thirdly, there is the fact that some states may argue that they are losing access to maritime space and resources. However, the UN clause does not require states to update their deposited baselines, and the real legal and practical concerns must therefore be addressed through safeguards and cooperation. Now, there are two more limits which must be discussed. Firstly, the preserving of a baseline does not decide the status of an island under 121.3, and a feature may still be assessed separately to determine whether it can sustain human habitation or economic life of its own. And secondly, ILC reports. Uh, Hello, am I audible?
Yes, continue.
All right. Yeah, sorry. So, secondly, ILC reports, political declarations, and advisory opinions may not be binding treaty rules, but they remain important because they guide treaty interpretation and reflect state practice. The objective is not to declare every issue resolved, it is to build a regional position that preserves existing rights without deciding unresolved disputes. Now, so we propose a hybrid model. The first part of this is a joint declaration by India, Bangladesh, and Sri Lanka. And the declaration would preserve existing normal baselines, state baselines, deposited maritime outer limits, and it will not amend the UN clause. It will, the states must attach precise charts, coordinates, any geodetic information. So the preserved limits are therefore made clear, and it must contain without prejudice clause, which will ensure that the declaration does not settle maritime boundaries, sovereign disputes, or the legal status of islands under Article 121.3. And so the declaration protects established entitlements, but it also keeps the contested issues open. And the second part of this model is a cooperative management protocol. Legal preservation alone is not enough, and it protects entitlement, but it does not manage the problems at sea. So states still need rules for their fisheries, for maritime protection, for offshore resources, and all. And the second part of the model is therefore a consent-based cooperative management protocol, where it may operate among all three states or between two states wherever necessary. And it does not alter sovereignty. It allows states to cooperate where maritime rights overlap or where there are changing coastlines which create practical difficulties. And so it converts the legal preservation into a workable maritime governance framework. Now, finally, this regional position must be prepared before, it is better if it is prepared before the UNGA high-level meeting on sea level rise, which is on the 24th of September 2026. India, Bangladesh, and Sri Lanka face connected coastal and maritime pressures in the Bay of Bengal, and a coordinated position can protect existing entitlements without overstating the current state of the law. And so the framework that we have presented is very clear: preserve established limits through a joint declaration, protect unresolved issues through a without prejudice clause, and thirdly and finally, manage practical consequences through cooperation. Thank you.
Okay, thank you, participants. We don't have any question for you. Thank you.
Thank you so much.
Now we move to our next presenter, P. Lakshmi.
Hello, ma'am.
Yes.
May I audible?
Yes.
Okay, ma'am. Good afternoon, ma'am. Good afternoon, sir. Respected panel members and everyone present here. My name is Lakshmi Simareddy from Christ University Kengari campus. Today I am presenting our research titled Efficient Lightweight CSCN Based Automated Waste Classification for Circular Economy and Sustainable Urban Waste Management. This research focuses on using lightweight and deep learning models for automated waste classification. So our problem motivation is like for this work comes from the increasing challenge from urban waste segregation. Manually sorting is a labor innovative and difficult to scale consistently. Computer vision and deep learning can help identify with an waste materials automatically from images. However, from particle deployment accuracy alone is not enough. Model size, inference time, and composition equipments are also important. So our thing is like therefore our research will focus on comparing lightweight citizen based approaches while considering both classification performance and computation efficiency. So our object and contribution is like the main objective was compared to three CCN based approaches under a common experimental setup. There was a custom baseline CCNN, which is mobile net V2 and efficiency VO. We used the TrashNet data containing around 2,527 images across 6 categories like a cardboard, glass, metal, paper, plastic, and trash. And we have been evaluated the models using accuracy, precision, recall, F1 score, and model size and inference time. So our data set and experimental methodology. For our methodology, the data set is divided into 70% of training and 50% of validation images and 50% of testing thing. So images are resized by 160 by 160 pixels. We applied augmentation techniques including horizontal flipping, rotation, and zooming. Because the dataset contains class imbalance, class weighted training was also added, used. So the same general evaluation framework was mentioned across the three models to make the comparison meaningful. So while coming to model architecture and training configuration, the first model was our baseline CCN consisting of three conventional stages, followed by global average polling and average classification head. The second model was a mobile VNet, which we use pre-trained configuration features and designed to a lightweight architecture. The third was efficiently Vivo, also using an ImageNet pre-trained backbone followed by classification and fine-tuning. All models use the same 6 classes classification objective with an add-on optimization and early stopping and doing training. So our overall model performance, the baseline CCN achieved an accuracy of 15.65%. Mobile V2 improved by the accuracy of 74.51%. The uh, efficient beaver achieved the accuracy across three models, reaching around like 79.90%. With a weighted F1 score, we have been predicted like 79.73%. So after comparing these three models, we got like an BCCNN and efficient beaver improved accuracy by a 29.25% percentage of points, and compared to the with a mobile net V2, it's improved accuracy by 5.75 percentage points. However, this improvement came with an increasing the model size and inference time. Therefore, the results demonstrate a trade-off between predictive performance and computational efficiency. So, while coming to class-wise efficiency BO, like looking at the class of performance of efficient net BO, the highest F1 score was obtained for paper at 88.52%, followed by cardboard at 86.89%. The trash category achieved an F1 score of a 66.61%. And even though for baseline CCN, we achieved like only 22.22% for F1 score. So, while coming to, oh, sorry. While coming to accuracy efficiency trade-off, we will consider computational categories. The baseline CCN was the smallest model and also had the lowest measured inference time. And mobile net V2 provided an intermediate configuration while efficient V4 achieved the highest classification accuracy. So while coming to sustainability and future work, from sustainability, pressure to automated waste classification can potentially support more consistency identification for recycled materials and future automated sorting systems. So while coming to conclusion, we compared three CCN based approaches for waste classification. Efficiently net Vivo achieved the highest accuracy of 79.90%, but with higher computational requirements, our results demonstrate the importance of an balancing accuracy with deployment efficiency. So that's all, ma'am. Thank you for your time, and I'm happy to answer your questions.
Okay, thank you, participant. We don't have any question for you. Thank you.
Thank you, sir. Thank you, ma'am.
All right. Now I would like to call upon Dr. Sridevi.
Yes. Is my screen visible?
Yes.
Yes. Thank you, everyone. So my topic is climate migration and justice among South Asian women. Why South Asian region is important? The World Bank had published a groundswell report which has identified six world regions to be affected with respect to climate. So in that context, South Asian region also has an important role to play, because when we talk about the different disasters that the South Asian region has seen, be it India, be it Bangladesh, be it Pakistan, Nepal, the Sri Lanka, etc. So there has been a lot of migration with respect to climate-induced reasons. And if you look at the statistics, people in around 700 million people in South Asia have been affected by climate change in the past, and the report foresees 800 million to be projected as migrants to be by 2050. And also, with respect to the ranking of countries, India ranks fifth among the 10 countries, the 10 most countries which is going to be affected with respect to climate migration. Climate issues are India ranks fifth and Sri Lanka ranks sixth as per the Global Climate Risk Index published in 2020. So almost half of the South Asian population is going to be affected with respect to climate change. And how does the state, how does the environmental concerns have to be addressed in such a way that the disaster, which when it is struck, how the community should be equipped in a way to face the climate issues. So India has the highest disaster displacement in South Asia. It is very important in this context how to address about their relocation, about their livelihood opportunities, and how the state have been addressed, looking at the climate migration mobility as an option, or as an alternate option for people affected with respect to climate change. If you're looking at migration, environmental reasons leads the family or the head of the household to migrate to different localities, which leads to unplanned migration. So when there is migration from rural to urban localities, there is more stress on the city resources, which where the city has to be prepared in such a way that they are willing to, or they are infrastructurally and other with respect to other resources, are in a position to accommodate these climate migrants. If you look at the onset of climate stress, there is slow onset of climate stress, which gives ample time for the households to relocate into different locations, be it sea level rise, rising temperatures, drought, heat waves, which actually affects families to relocate. So that gives enough time for the household to migrate. So 37.4 million are the projected displaced migration in South Asian countries by 2030, and 62.9 million are the projected displaced migrants by 2050. So this is going to be an alarming number, and 2050 and 2030 is not so far. So how are the countries facing these kind of migration challenges, be it Bangladesh, Nepal, India, Pakistan, and Sri Lanka, and how to help these families migrate with respect to different localities, and what should be the way of looking at it. Looking at the migration statistics, people migrating for livelihood reasons, as per the International Organization of Migration, India sees 17.7 million of migrants, followed by Bangladesh and Pakistan. So all these regions come in the South Asian region, where it becomes much more important to address this as a concern. And internal migrants, so when migrants, so we are not talking about international migrants who are shifting to different European countries for better employment. We are talking about livelihood people who are in the vulnerable communities, who do not have an option to move to an international country, but they prefer to move within the country. So internal migration is also an important issue within South Asia, where when people migrate, nearly 4 times the number of international migrants. Internal migrants are 4 times the international migrants. So there is more stress on the state itself, how to allocate the resources and how to plan for a better migration options or opportunities for the family. So most people, they prefer to move within the country where they cannot afford for an international migration. And looking at the environmental hotspots in South Asia, we can see all these South Asian regions have seen overlapping hazards with respect to coastal flooding, cyclones, and water stress, and other heat waves, and other cyclones and sea level rise, etc. So all these regions are hotspots when we talk about climate migration. And here I would like to stress the role of women. We know women is considered to be agents of change, and how to invest in women communities and women leadership, and how to empower women so that they also make decisions for the family. So when the male head of the household migrate for because of this environmental reasons, how to ensure that the female in the household also gets to play an important role with respect to making decisions. When we talk about the rights of women, we know that many of the property rights are not assigned with women, and they cannot make any big decisions in the family, and they are the secondary earning member in the household. So when the male person in the household migrate, the main decisions have to be taken by the women in the household, and we know about the double burden of care, the burden that is there on the women when we talk about decision making, family decisions, about maternity health, and all of that. So looking at the workforce participation, for example, so 32% of women participate are in the labor force participation, compared to 77% in the among men. So we know, so when we look at the how women's work is accounted, it is not really showing in the data as such. So how their hardship in low skilled work is an issue. So when they are represented mainly in the informal sector, in the care economy, how it is less represented. What about left behind families? Research and migration shows that when women leave the family,
Participant,
women,
move to the
yeah.
conclusion. You had exceeded time. Yes.
Yes. So the main policy suggestions would be, first one is insight adaptation. So we cannot have the same kind of plan for all kind of disasters. There should be insight adaptation with respect to how we have Japan is friendly, their infrastructure is friendly with respect to earthquakes. Similarly, insight adaptation for particular climate issues, plan relocation with dignity. There is no concept of climate refugees. So in that way, how do we address it? So plan relocation of these affected families with dignity. Migrant inclusive policies, how much of the policies actually consider migrant inclusion, and also gender specific data, how many of women are specifically affected, and it's also not sensitive. We cannot generalize the experience of every family, be it in Nepal, Bangladesh, or India. So there should be a gender specific data with respect to gender specific vulnerability, data collection, gender sensitive adaptation, and also community engagement, how we can enhance women's active participation with respect to decision making in climate response. Thank you. That will be from my side.
Okay. Thank you, participants. We have no question from you.
Thank you.
All right. Now we move to our next presenter, Mr. Khemraj Sharma. Yeah.
Am I visible, ma'am?
Yes, it is visible.
Yeah, thank you. Good afternoon, respected panel members presented over here. So today I will explain my research role of financial institution in promoting sustainable agriculture and climate resilience in Kerala, policy and practices. So I am research scholar from IIT Vadodara, Department of Humanities and Social Sciences, and working under the guidance of Dr. Vikas Kumar. So starting with the introduction, agriculture is an important component of Kerala's economy. As we all know that Kerala has a distinctive plantation-based agriculture economy and produce rubber production over 75% of India's natural rubber. And farmers face several challenges like small and fragmented land holdings, labor shortage, climate variability, rising production cost. So institution financial is important for timely credit, technology adaptation, and farm mechanisms. So my research problem is Kerala has a highly developed banking network and financial inclusion. So existing studies are largely focused on agriculture credit, individual finance and rural banking. But there is limited researches that examine commercial banks about private commercial bank, cooperative banks, NABARD, Kisan credit cards. So there is also limited evidence on RKVY, NABARD and KCC. So my research aims to examine the structure of distribution of banking institutions, analyze government reports for agriculture through RKVY, Raftar, NABARD, and Kisan Credit Card. So, starting with the study area and methodology, my research approach is descriptive and analytical research and theoretical framework is financial intermediation theory, in which we can see that financial institutions supports agriculture finance, and with the help of agriculture finance, there is agriculture investment in state. So, it cause of agricultural development, and this is study based on Kerala state, and the data used for this study is secondary data from NABARD reports, RBI reports, Government of Kerala, state planning reports. So in figure one results, we can see that allocation under RKVY scheme, Rashtriya Krishi Vikas Yojana scheme. In this graph, we can see that in 2016-17, there is 154.6 crore allocate in this scheme. And similarly, we can see that in 2018-19, there is 127.606 crore. And we can see there is significant decrease from the year of 2019-2020 to 2023-24, we can see that there is only 23.73 crore is allocated. And now move forward to banking group institution branch network in Kerala. In this pie chart, we can see that there is highest number of share from public sector commercial bank. There is 42%, and private sector commercial bank from 34%. Similarly, we can see that there is cooperative banks and regional rural banks from total 20%, cooperative banks from 12%, and regional banks from 8%. And this data is compiled from the Government of Kerala report. And in figure 3 and figure 4, we can see that there is agency-wide distribution of NABARD finance assistance in Kerala state and agency-wide distribution of Kisan credit cards in Kerala. In both graph, we can see that there is highest number of allocation in regional rural banks in NABARD finance, and we can see there is commercial banks highest number of shares. KCC like 1 lakh 30,000, oh, sorry, 13 lakh 9,566 in year of 2023 and 2024. There is a agency-wide distribution in NABARD refinance. There is also comparison of year 2022 to 2020, year 2022 2024. So finally, I will conclude my all the slides here that financial institutions are an important component of agriculture development in Kerala, and KCC distribution has expanded sustainability, particularly through commercial bank and private sector banks. At the same time, the declining RKY allocation, it raised concern about the continuity of government support for agriculture development in Kerala state and strengthening institutional credit, cooperative banking, KCC access and policy coordination and contribute to more resilient and sustainable agriculture development in Kerala state. Also, public sector commercial banks dominate the banking network while private banks have an increasing role. So these are the references which I have been using in my all the slides. Thank you.
Okay, thank you, participant. The panel has no question from the for the presentation you had presented. Yes, thank you.
Thank you, sir.
All right, now we move to our next presenter, Miss Komal Kumari.
Hello, good. Am I audible?
Yes.
Hi, good afternoon, everyone. So, my topic is decadal change in the area of Vasai Virar. When we talk about urban growth, every inch of the land is not just a development, but it is an issue of climate governance. Especially when we are talking about the coastal low-lying regions that face compounding in with the risk of floods. The question is who is responsible and how the resource allocation should be done. It is not only about the construction, but how the growth pattern is increasing in any area, and the equity should be provided to everyone. Now, the study area that I'm covering is Vasai Virar region, which is situated in the northern Mumbai metropolitan region of the Palghar district. It is a low-lying coastal plain with the tidal creeks, estuaries, mangrove patches, salt pans, as well as agricultural land. The region receives around 2000 of annual rainfall, and it is having a good connectivity and affordable housing, which attracts most of the population towards the region as it provides a better connectivity with the Mumbai city. Here we used the uh, here we use the cloud-free Landsat overlay imagery for 3 years, that is 2015, 2020, and 2025. Then the spectral indices such as vegetation index, built-up index, as well as modified water index were studied. Now these indices were then ran for the four classification, that is vegetation, water, built-up, and barren land using the random forest, and we validated the accuracy using the confusion matrix kappa, and then the validated values were then used for the change detection in the land use pattern and spatial analysis. Talking about the classification reliability, we have seen that the vegetation over the year have increased from 42% to 49%. There was sharp decline in the barren land, that is from 31.4% to 22%, and the built up, of course, increased from 18.6% to 21%. Around 11,000 patches were utilized for the study of the indices of all the four classes, that is the built up, water, barren land, and vegetation. So, in the year 2015, it was seen that there was a gradual increase in the built up region where only 2.47 square kilometer of the area was utilized for the growth utilization of the built up, whereas that increased up to 8.61 square kilometers by the year 2025. The key finding over here is that not the buildup is not mostly done by cutting the vegetation or declining the vegetation, but the utilization of barren land was done.
Participant, you are not audible.
Hello.
You are, yes, now you are audible. You can continue. Yeah.
Okay. So the barren land contributes more to the built-up area, as these lands were mostly used for the salt farming, or they were marshy lands. Talking about vegetation, there is, of course, some parts are still removed for the recent developments like the new railway lines, and there is persistent increase in the urbanization. Now the question is, we all know that there is urbanization, but in what part and how the growth is going? So the growth is non-linear. Earlier, we have seen that the density or the fragmentation growth is mostly towards the northwest side of the region and not in a uniform manner. That is, The northwest region of this Vasai area is highly populated with 39.10% of the people residing as compared to the other regions of the area. The most of the important region is this particular northwest area is having different communities living together. Most of the resources are provided. The area is having plains and water availability is provided as compared to the other parts of the study area. So that boils down to the policy and governance, because if we are talking about SDG 11, where we talk about smart cities and infrastructures, it is important to understand the not only the urbanization but the pattern and the growth of urbanization first. Second, climate justice should be provided with equity and not equality. And lastly, when we are talking about people, the justice should be provided with respect to the resources, and the land should not be burdened with the urbanization. Thank you.
Okay, participant, my suggestion is the paper lacks a critical analysis portion from the policy centric view. Like you have to take consider like those countries where they had been implementing such kind of policies which I would recommended. You can take reference from those country models. I will tell you to look into the Europe centric models where already there are a number of policies which you had come up in your recommendations. Thank you for your presentation.
Okay. Thank you so much, sir.
All right, moving ahead, I invite Miss Ankita to present. You can start your presentation.
Okay, ma'am. Is my screen is visible, ma'am?
Yes.
Okay.
Participants, start with your presentation. Don't delay.
Okay, sir. So, good evening, everyone, distinguished guests, faculty members, and fellow researchers. I'm Ankita, co-author of this research paper, along with my co-author Anurag Chaudhary. Our paper title, Reconstructing Environmental Governance for Climate Justice and Right-Based Framework for Sustainable Development in South Asia. Our research examines why climate injustice continue in South Asia despite the existence of several environmental law, constitutional protection, and international commitment. These slides explain why climate change is more important than an environmental problem. First, it threatens environmental sustainability through rising temperature, glacial melt, sea level rise, and extreme weather events. Second, it creates human rights concerns affecting rights such as life, health, food, water, and a clean environment, particularly for vulnerable communities. Third, it becomes a barrier to sustainable development because repeated climate shocks can affect agriculture, infrastructure, and public finance. This leads to the central puzzle of our research paper is the crisis caused by an absence of law or by weak governance of law that already exists. South Asia is not necessarily short of legal and policy commitment. We have already constitutional environmental rights, national governmental laws, national adaptation program of actions, and international commitments such as the UNFCCC and the Paris Agreement. However, there remain a significant gap between law on paper and the climate justice in research. Weak accountability, fragmented institutions, and poor enforcement prevent existing commitment from producing effective outcomes. Therefore, our research question is whether a deficit is actually one of law or fundamentally of environmental governance. Our research has four main objectives. First, we aim to diagnose the gap by examining why constitutional rights, statutes, and climate commitments are not translating into outcomes on the ground. Second, we evaluate existing governance structure, including environmental institution, court ruling, and comparative constitutional principles. Third, we design a workable, right based environmental governance framework or RBEGF
capable of operationalizing climate justice. And fourth, we recommend a practical way of forward by strengthening accountability, participation, and regional cooperation without necessarily requiring completing the new legislation. For this research, we have used qualitative doctrine legal research. We analyze international environmental law, constitutional principles, court ruling, and South Asian governance system. Our methodology has three approaches. The first is descriptive, which maps the existing legal and institutional landscape. The second is analytical, which examines why constitutional and statutory guarantees often fail to produce climate just outcome in practice. And third is comparative, where we compare governance model and judicial approaches across the South Asian states to identify practices that may be transferable. Now, this slides present the major bodies of authority examined in our research. We look at the international law, including the UNFCCC, Paris Agreement, and the Stockholm and Rio Principle. We also examine constitutional provision, particularly environmental and life-related rights. Third, we analyze judicial precedents, including important environmental and climate-related cases. We then consider national policy and domestic legislation, including climate action, environmental protection, and disaster management framework. Finally, we consider regional cooperation mechanism, particularly SAC and other regional arrangement dealing with the transboundary environmental issue. Our final our final findings indicate the gap is structural rather than merely doctrinal. We identify five major governance problems. First, fragmented institution where overlapping mandates dilute accountability. Second, weak enforcement where environmental rights may be recognized but compliance and monitoring remain inconsistent. Third, limited public participation, particularly for affected and vulnerable communities. Fourth, science policy disconnect, where climate data does not consistently inform policy. And fifth, shallow regional cooperation, even though many climate risks are transboundary. These findings lead us to our proposed framework. Our core contribution is the right-based environmental governance framework. The framework is designed to operationalize climate justice through six integrated elements shown on the slide: human right integration, accountability, mechanism, inclusiveness and participation, intergenerational equity, science-based decision making, and regional cooperation. The important point is that our framework does not simply call for more laws. It focuses on making existing legal commitments more effective through better governance. To operationalize the framework, we propose six main measures. First, institutionalize accountability through independent environmental oversight and monitoring. Second, embed community participation, especially consultation with affected and indigenous communities. Third, strengthen the science policy in connection through scientific advisory mechanism. Fourth, deepen regional cooperation, particularly through SARC and bilateral mechanism for transboundary adaptation, water, and disaster risk governance. Fifth, codify intergenerational equity in long-term planning and budgeting. And sixth, build implementation capacity by providing adequate resources to local and state level agencies responsible for enforcing environmental and climate law. To conclude, the central argument for our research is that the obstacle to climate justice in the South Asia is not simply an absence of law, but the absence of governance capable of effectively enforcing it. Our right-based enforcement governance framework provide a possible route for commitment to compliance by intergenerating human rights, accountability, inclusiveness, intergenerational equity, science-based decision making, and regional cooperation. We believe that strengthening these government dimensions can help South Asian states to move closer towards meaningful climate justice and sustainable development. Thank you very much.
Okay, thank you, participants. We don't have any question for you. Thank you.
Okay, thank you, sir.
Okay, our next presentation will be by Arsulvat Janardhan.
Hello, good afternoon, Chair.
Yes, you can start.
Am I audible?
Yes.
afternoon, sir. This is Janardhan, and my paper title is like Carbon Governance and Climate Justice in Need for Marginalized Communities of Southeast Asia, where it has been 2 decades of the burden which falls upon the global south, and still it has little role in designing the timeline. Here in my paper applies the three justice framework: procedural justice, distributive justice, and restorative justice, under two regimes: RED Plus and CBAM, which is Carbon Border Adjustment Mechanism, under the case studies of Vietnam and Indonesia. And here in my what is carbon governance? The rule book which have been fighting for the climate changes, and institutional such as domestic laws and international treaties like Paris Agreement, and then the private carbon markets. Next, why Southeast Asia carries the weight? Here in the world's 15% of world tropical forest exists, and region land is covered up approximately 43%, and global green gas emissions are being stored at 13 to 7% in this area. And here has a retrospective effect on the sea level rises in Vietnam and Cambodia, which is nearly been affected, and intensifying tufans between in the Philippines and Vietnam. Also droughts in Thailand and Indonesia hits the hardest in the marginalized communities of Southeast Asia. So it carries the weight as a global south. And who makes the rules? And the legal frameworks like Paris Agreement and the Cumming Moratorial CVM and UNDRIP. And here the three dimensions of justice that I've previously exhibited, that is carbon, distributive justice, procedural justice, and restorative justice. Here the distributive justice shares the resources between the affected area. The burden and risk will be affected the people, and there it's turned to cover the cultural and the lifestyle of the people of Southeast Asia. Then procedural justice, the fairness in decision making under Article 32 and 19 of the UNDRIP, free prior consent, that is. And restorative justice, repairing the past harms which have been made for the burden which has been fall upon the Southeast Asia. And the failures under the RED Plus mechanisms under UNFFC and national strategies, where the Article 19 was been overruled and been breached by the frameworks, and institution have been manipulated under the, despite being in the Cambodian baseline. And then third place, and the transparency been not maintained under the agreement of UNFCCC, and the Paris Agreement was been made. And then carbon governance meets the trade law. Here the transitional period when the reports will be collected on the financial basis, and where there was no transaction of finance. And definitive phase, and it starts about on 26th, right? And the import purchases should be surrendered the certificates before the CBAM. And pricing certificate will be mirroring the UNEP's ETS allowances. And the BRICS, why it has been opposed under the trade law? Because there was a unfair trade practices, violated the CBRM, unilateral in the design and trade distortion, and the economic inequity for the development exporters. And here they proposed the reforms that differentiated exceptions for developing economics, climate finance linkages tied to CBAM revenue, build capacity for supporter exporters, and WTO-led global carbon floors, and especially for the differentiated under WTO rules. And lead reform recommendations, the forest governments binding to FPIC, recognize land rights of the marginalized communities of Southeast Asian people, and guarantee minimum share of carbon revenue to communities. And carbon trade, redesign the CBAM with longer transitions, embark funding, and multilateral WTO accommodation clarifying PPM to trade measures. And the institutional monitoring should be enhanced through the justice system, that even special priority can be on the carbon and community rights with mandatory and mandatory human rights assignment for the RED Plus and CBAM. Joint UNFCCC with led by WTO should be monitored. Here is the floor for the questions. Hello, am I audible?
Yes, the jury don't have any question from our end. Thank you for your presentation.
Thank you, Chair.
Moving ahead, I invite Ms. Gitu to present. You are not audible.
Can you hear me, ma'am?
Yes.
Yeah, thank you. Good afternoon, everybody. I'm Geetu S. Thodamaril, Research Scholar at Wales University of Chennai, and my presentation is titled From Policy to Practice Evaluating India's Legal Readiness for Green Technology Adoption in the Era of Climate Justice. Just before discussing the legal readiness, I think that is very important to understand what is meant by green technologies. Green technologies are those technologies and products and processes that seeks to reduce the environmental harm, improve resource efficiency, and support the transition towards a sustainable and low carbon economy. India has already demonstrated considerable policy ambitions in these areas. We have climate and energy missions, renewable energy initiatives, the National Green Hydrology Mission, and emerging carbon technology market. However, my research begins with a very different question. Is the policy ambition alone sufficient to achieve the effective green technology adoption? My argument is that it is not. The green technology adoption requires clear legal rules, effective institutions, predictable regulatory processes, enforcement capacity, and mechanisms that ensure fairness for affected and vulnerable communities. Therefore, my paper evaluates whether India is legally prepared to move from policy ambition to legal readiness and ultimately to climate just implementation. The problem the central problem addressed by my research is the gap between policy adoption and legal implementation. We all know that India has introduced several important climate and green technology initiatives covering renewable energy, energy efficiency, etc. However, announcing a policy is not only the only first step. For these technologies to be implemented effectively, the legal system must provide clear rules and standards, coordinated institutions, predictable approvals, and effective enforcement. So, there is also a second dimension to this problem climate justice. The transition to green technologies can create both benefits and burdens. Therefore, we need to ask who benefits from the transition, who bears its environmental and social cost, and do affected communities have meaningful opportunities to participate? This leads to the three questions underlying my research. Is India's legal framework adequate? Can institutions effectively implement it? And can implementation take place in a climate just manner? To answer these questions, I first examine India's existing legal architecture. India actually has a substantial legal foundation for environmental and climate justice thanks to the legislatures. At the constitutional level, we know that Article 14 and 21 provide important protection relating to equality of life, while Article 48A and 51AG establish constitutional environmental responsibilities. These constitutional principles are supported by important statutes, including Environment Protection Act, Energy Conservation Act, Electricity Act, and National Green Tribunal Act. At the policy level, India has the National Plan for Climate Change, Renewable Energy Initiatives, the National Green Hydrological Mission, etc. Therefore, my finding is not that India has no law. The more important issue is that whether these different constitutional, statutory, policy, and regulatory components can function together as one coherent implementative system. Judicial development. You know that in the flowchart in my PPT, that Indian judiciary has also played a very important role starting from 1990, since from the institution of constitution through 1996 through Fellow Citizen Welfare Forum, in 2011 Lafarge case, and 2018 Aroskar case, and even in 2021 the very famous MK Ranjit Singh versus Union of India. The court recognized the protection from adverse effects of climate change in connection with Article 14 and 21. This is particularly significant from the perspective of climate justice because climate impacts are not experienced equally and vulnerable communities may face disproportionate consequences. Thus, Indian constitutional jurisprudence now provides a very stronger foundation for climate protection. The challenge is to translate this constitutional foundation and judiciary activism into actual implementation. This comes to my very original contribution of my paper, which is Green Technology Legal Readiness Assessment, or I call it as GTLRA. I developed this framework to move beyond simply by asking whether the laws exist instead of asking whether the legal system is actually ready to support the green technology adoption. My framework evaluates the five dimensions as you can see in the PPT. First, normative readiness. Does the legal system actually provide sufficient authority for green technology adoption? I assess this as a very strong thing. And second, regulatory readiness. Are these rules, standards, approvals, and safeguards sufficiently clear? I assess this as moderate. Thirdly, institutional readiness. Do the relevant agencies have the capacity and
Sorry to
coordination?
interrupt. Please
Yes,
conclude
ma'am.
your presentation.
Yeah, just 2 seconds, ma'am. Fourthly, the justice readiness. And finally, adaptive readiness. The central insight of GTLR is therefore very simple. Having legal authority does not necessarily mean having implementation capacity. Due to the shortage of time, I just conclude that my assessment is not that India is legally unprepared. India has already constitutional principles, important legislations, initiatives. The real challenge is the gap between policy ambition and implementation challenge. Therefore, the central proposition of my paper is that India must move from policy ambition to legal readiness and finally to climate just implementation. Thank you very much. And I welcome the questions now if there is any.
Okay, thank you, participant. The jury has no question for you.
Yeah, thank you.
Now I would like to call upon Ms. Aditi Sharma for the presentation.
Am I audible and visible?
Yes.
Okay. Right. So, good afternoon, everyone. Good afternoon, members of the panel. My name is Aditi Sharma, and my topic is India ready for a fundamental right against the adverse effects of climate change? It is a case comment and a critical analysis of Supreme Court's 2024 judgment, M.K. Ranjit Singh versus Union of India, which interpreted a new fundamental right, which is right against the adverse effects of climate change. So this case was brought before the Supreme Court because of the critical endangerment of two birds belonging in the state of Rajasthan and nearby states, which is Great Indian Bustard and Lesser Florican. The main threat to these species was the fatal collision with the high voltage overhead transmission lines, which are required for the India's major solar and wind projects and India's commitment to Paris Agreement and United Nations Framework Convention on Climate Change. The conclusion of the judgment is not something that I'm going to deal with. It's what the Supreme Court interpreted. It's a fundamental right against the adverse effects of climate change. So I'm going to quickly tell why this analysis is important of this new fundamental right. Quoting from my research paper, first, that it brings something that India has not dealt that much with. It is the intersection of climate change and human rights. Second, it has opened doors for future climate change lawsuits. Till now, we did not have any such precedent or legislation which talked about climate change lawsuits. So this judgment does that. Thirdly, it has broadened the interpretation of Article 21. And fourthly, it has given a very significant judgment that it has acknowledged the challenge of intersectionality when we talk about human rights in climate change. What this intersectionality is, I'll be briefly talking about it in a while. So moving on to the two articles that the Supreme Court has dealt with, Article 21 and Article 14. In Article 21, Supreme Court said that till now we have environmental legislations like Wildlife Protection Act, Conservation Act, Environment Protection Act, Air Prevention and Pollution Act, but we do not have any legislation that is specifically on climate change. So the Supreme Court recognized that now there is a need to have a distinct right on it. So, which is why it also gave a very landmark line, which is without a clean environment, which is stable and unimpacted by the vagaries of climate change, right to life is not fully realized. And hence, that's how Article 21 comes in picture. About Article 14, Supreme Court said that when climate change has some effect, it is different on different communities. So it gave the example of people residing in Lakshadweep Island versus people residing in Madhya Pradesh. Definitely in this case, people residing in Lakshadweep are more disadvantageous, which is why there is a need to equalize their position. Supreme Court briefly, the major milestone of this judgment is that it has acknowledged intersection of climate change and human rights, where already there has been international discussions on it. So there is a plus point. However, more than the positive developments, there are implementation vacuum in this judgment. So there is need for more changes in this judgment or in the consequence of the judgment than in the positive development. So first, implementation vacuum is a very big one. It is a legislative void. So we all understand that bringing a right as a status of giving it as a status of fundamental right is huge, and it provides more onus on the state to make sure that this fundamental right is not violated. But what will state do in this case when there is no legislation on climate change, no legislation on human rights in climate change? So which is why it entirely now comes down to judges to on case to case decide, which is not viable for judges to do that because of the lack of scientific expertise. Second is the ambiguity in this word adverse effects of climate change. What is adverse effect? We do not even know. So any minor event can also come in adverse effect. For example, a huge heat wave, a simple heat wave can also be an adverse effect. Third is the role of non-state actors. Research says that 57% of carbon producers are the private entities, and which is why there is no mention of private corporations in handling climate change. And the last implementation vacuum is the geographic disconnect. So the impact of climate change can come from a different place and can have on a different place. So how are we gonna decide who is the perpetrator, who is the victim? So this is another major issue, and these things have not been answered in the judgment. To conclude, it is a milestone that we have something called as a right against adverse effects of climate change. It recognizes climate change lawsuits, but at the same time, there needs to be a tailored framework which is for climate change rights, so that we and the state both know what to do with this right against adverse effects of climate change. Thank you. I can
Okay,
hold my.
so participant, like there are two suggestions from my end. When we look into the climate activism and the role of judiciary in it,
Yes.
so but there are two aspects. First is the common law aspect, and second is civil law aspect. When we
Right.
look into common law aspect, it is the role of the judiciary in a fundamental way to write up the rules and regulations which is not written like by their precedents. But when we look into the civil law aspect, they will only decide upon the facts where the rule is mentioned. They will just dictate it. They will not go beyond that thing. So my point is, your paper is pretty much good, but it should include these two aspects: how the countries across the world is dealing with the environmental challenges and the environmental
Right.
justice system.
Yes.
Where
Sir, in
like
my paper, I have included 3 cases. In the presentation, I did not mention
like
because of.
three cases will not be enough to come up with this aspect. It needs to
Right.
delve much deeper. The aspect is
Okay.
much deeper. So that's my suggestion. It should include
Okay.
into it.
Yes, sir. Thank you. Thank you. I'll take it into consideration.
Okay. Thank you for your presentation.
Thank you. Thank you so much.
All right, now we move to our next presenter, Madhiroja P.
Am I audible, ma'am?
Yes.
Vanakkam. This is Madhiroja, and I am going to present about the topic on e- one title slide. Title slide.
You are
Okay, so
visible and audible. Kindly continue. Yes.
yeah, I will continue so soon. My title is about ecocide recognition towards a global environmental governance. And herein we can see that the climate change is a transboundary harm, and there is an existing legal framework such as a Paris Agreement, which remains voluntary and lack binding enforcement mechanisms. It is a need of heart to recognize the ecocide, and thus we choose this title, Climate Justice via Ecocide Recognition towards the Global Environmental Governance, which underscores that how ecocide links climate change impacts with environmental justice, thereby positioning the accountability as a pivotal point of our research. And this is the review of literature wherein Richard Falk in the year 1971 coined the term ecocide, which is an unwanted destruction of an environment as a crime against the peace. And in the year 1972, the Stone proposed the legal rights for nature. In the contemporary era, in the year 2025, Prodro and Pavanera says that the framed climate change is an ecocide, and they argued that criminalization only strengthens this governance. And the methods we choose in this research is doctrinal and comparative legal analysis only. And the objective behind this research is to analyze doctrinal foundations of ecocide and propose statutory reforms at the International Criminal Code for ecocide recognition and making it a universal accountability. The limitations which include it is restricted only to the purely doctrinal research, and this does not contain any empirical data. And the research problem one is that the binding enforcement deficit, wherein it leads to the question: how can ecocide recognition address the enforcement deficit? And the hypothesis we framed is that the ecocide recognition strengthens the climate justice enforcement. The findings include voluntary frameworks leads to weak accountability, and inadequacy of a civil liability leads to more global harm, and ecocide recognition leads to enforceable justice. We suggest that to amend to the Rome Statute to codify ecocide under Article 8.4b and to complement the Paris Agreement and other relevant environmental agreements with binding accountability and to build global prosecutorial capacity. The research problem 2 is fragmented environmental rights across jurisdictions, wherein it leads to the question: can International Criminal Court regional harmonization overcome this type of fragmentation? And the hypothesis we framed is harmonization creates universal accountability framework, and the findings are regional tribunals has inconsistent recognition, and these types of fragmentation leads to weak enforcement, and harmonization is the only solution for coherent accountability. And we suggest to institutionalize the International Criminal Court with regional cooperation agreements and facilitate the joint investigation methods and mutual recognition, and to align global accountability with regional jurisprudence. The third research problem is that the ecocide lacks universal accountability beyond sovereignty, which leads to the question: can ecocide recognition universalize the accountability beyond sovereignty? Hypothesis we framed is ecocide recognition transcends sovereignty, leads to universal accountability, and the findings are: one side, your sovereignty limits the enforcement, and other side, the fragmented across the jurisdictions, which leads to lack of accountability. Thus, the solution here is the ecocide recognition is the only universal standard, and we suggest to codify ecocide under Rome Statute to strengthen the International Criminal Court regional tribunal cooperation and to encourage domestic incorporation of ecocide provisions, and also to embed ecological protections as a pillar for global environmental governance. To conclude, the climate justice remains an aspirational without binding enforcement, which elevates the ecological harm into international criminal law, which abridges the justice with accountability, and it leads to fulfilling the promises of climate justice. The future scope includes to codify ecocide under Rome Statute, harmonizing the International Criminal Court frameworks and other legal frameworks with regional tribunal jurisprudences, and to integrate the ecocide provisions into domestic law for effective prosecution. Here is a paradoxical thought that plants can survive without humans, but humans cannot survive without plants. Ecocide should be the fifth international crime, and it needs recognition, and it is a need of one heart. Stop ecocide, become an earth protector. Make ecocide a crime. Thank you.
Okay, thank you, participant. We don't have any question for you. Okay, thank you.
Thank you, sir.
Okay, now I would like to call upon Ms. Nisha Sharma for the presentation.
Participant, you are not audible and visible. Be quick. Kindly unmute yourself. You are not audible.
Am I visible and audible?
Yes.
Yes. Please be a bit louder. Your voice is low, and you can start.
Perfect. I will just take a minute. Okay. Good afternoon, esteemed colleagues and delegates. I'm Nisha Sharma, a full-time PhD scholar from CCES. Today, I present a public policy reconstruction framework, which is designed to solve one of the greatest governance challenges of our era, which is the widening gap between ambitious climate pledges and actual deliverable outcomes. So let's diagnose the core issue: symbolic green governance. Now, across administrations, we see performative goal setting, announcing targets without implementation mechanism, treating sustainability as a rhetoric rather than a core operating tool. However, the real world cost of this performance is now measurable in degrees. Moving forward, per the latest UNEP data, current policies lock us into 2.8 degrees Celsius of global warming by 2100. Now, to stay on a 1.5 degrees Celsius pathway, we need a 26% cut straight in emissions by 2030 and a 46% cut by 2035. Yet, the annual emission gap remains staggering. So I think pledges are not policies, and the gap is constitutional, not technical. It's all about where sustainability as a concept is sitting in the entire hierarchy of decision making. Moving further. Now, why does the symbolic governance over substantive trend persist? So, my research points to five structural causes. First, institutional fragmentation. Then there is trade-off avoidance. There is indicator distribution. There is lack of legal effect and capacity gaps. Now, to fix this, now that we know what the problem is, to fix this, we need a public policy reconstruction framework which is grounded in five core and most fundamental principles, naming environmental integrity, then there is intergenerational equity, there is resilience, there is democratic fairness, and then policy coherence. Rather than treating sustainability as a checklist, as a green box, our framework structures governance across eight mutually reinforcing dimensions, naming, anchoring long term directions with legal backing, then embedding ecology into public budgets. There has to be upskilling of the institutions by the institutions and co designing policies with vulnerable populations as well. Now, if we look at the implementation and the implementation gap, basically, even full execution of existing NDCs only gets us to 2.3 to 2.5 degrees Celsius. So the missing variable is a systematic policy reconstruction that what we calls for or what is the need of the hour. So we don't really need to reinvent tools or we don't really need to reinvent from scratch. I think we need or we must bind existing anchors together, like use of the taxonomy model for clear definitions, then leverage OECD guidelines basically for whole of the government coherence and aligning everything with the Paris Agreement NDCs. So to conclude, basically, I would come, sorry. So to conclude, symbolic governance is not really, no longer a viable, like the 2.8 degrees Celsius trajectory. It is proving its failure. So we must transform sustainability from a very performative discourse into a very binding public obligation, and that is what the need of the hour is. So if I have to give my 2 cents as a researcher, what we need is not promises. What we need is promises along with thorough execution, and it must move from the margins of environmental ministries to the very core of government structures. It doesn't really has to be something that is rhetoric and is on the paper, but it has to be something that is brought into the legislative structure or is got into the entire system from the core and from the fundamentals. Thank you. That's about it. If there is any question, I would love to address them.
Okay, thank you, participant. We don't have any question for you. Thank you.
Thank you, sir. Thanks.
Now I would like to call upon Dr. Kavita Rai. Yes, ma'am, you can start your presentation.
Good afternoon, respected chairperson, distinguished members of the panel, and the fellow academicians. Myself, Dr. Kavita Rai, Assistant Professor of Law at SVKM's Praveen Gandhi College of Law, and I am presenting this paper titled Heat Waves and Climate Governance in India, Rethinking the Legal Framework for Climate Adaptation. Our central concern is as heat waves predominantly have become more frequent and severe, is India's existing legal policy and framework adequate to meet the challenges of climate adaptation, and what statutory mechanisms are necessary to fight with it? Primarily, India doesn't lack a framework for executing or respond to extreme heat. We have Disaster Management Act in place with its institutional mechanism and architecture like NDMA and NDRF in place. Constitutional jurisprudence with a recent Supreme Court pronouncement is N.K. Ranjit Singh versus Union of India, which has recognized right against adverse effects of climate change, incorporating Article 14 and 21, and the recent and most important facet as recognition of inclusion of heat waves within the nationally notified list under the disasters framework, which really strengthens the response mechanism. But this again raises this central question: do these developments actually create clear and enforceable duties of heatwave adaptation? Our argument is that this critical gap lies between constitutional recognition, institutional mechanisms, and the legally enforceable adaptation obligations. This slide primarily focuses on why we conceptualize heat waves, not simply as extreme weather events, but as structural governance challenge. All these figures are alarming, talking about Lancet reports saying 546,000 annual heat deaths reported, global loss in labor productivity amounting to USD 1.9 trillion. From India's perspective, as this figure shows, that it is expected to lose 5.80% of total working hours due to heat stress, which significantly poses a duty upon us to take it in such a manner wherein we are ready to face it. Even in the ministry, as per the reports of Ministry of Home Affairs, in the past 7 months in 2026 itself, heat stroke cases were reported, and 4853 heat stroke cases and 20 deaths were reported. So why this is important per se is because this burden is not evenly distributed. 90% of India's workforce is primarily into the informal sector, concentrated exactly where the heat exposure and lost hours are there. Talking about the agricultural and the construction workers, and leading to its harsh effects on health uh, to the vulnerable people like elderly, pregnant women, children. Talking about the constitutional jurisprudence, it has mainly evolved from environmental protection to climate rights. As Article 21 has progressively expanded from a protection of life and personal liberty to encompass the right to clean and healthy environment, as stated in Subhash Kumar versus State of Bihar, in Sachidanand Pandey's case, Vellore citizens, MC Mehta versus Kamalat. All these have through judicial activism, the courts have always recognized and give a wider interpretation to Article 21. And currently, as my fellow colleague before me has pointed out, the pronouncement in N.K. Ranjit Singh versus Union of India recognizing a right to be free from adverse effects of climate change. And we see that heat waves has become an immediate effect of climate change. So what this is, but this creates this mechanism, it creates a critical gap for our research. Recognizing constitutional right is one thing, but translating that right into specific enforceable duties of climate adaptation is still to achieve. India does have a substantial statutory framework in place with respect to Environmental Protection Act, where the central government has immense power to issue notifications, to mandate directives, and take up scapes, set up bodies under it, including Disaster Management Act, which was previously pointed out with the NDMA in place. Also, UDMAs must prepare UDMAs have been authorized to prepare urban vulnerability plans. However, till date, only Karnataka has constituted one. This shows how seriously the government has been taking it. The regulatory gap lies in the absence of clearly defined enforceable duties, institutional accountability, and minimum standards specifically for heatwave preparedness and adaptation. In other words, we can say that coordination power exists, but enforceable heatwave obligation is still lacking. The August 2026 MHA notification has included heat wave and lighting enabling eligible states across access to this disaster response funding for these events, as this was followed by 16th Finance Commission recommendation. However, there are various caveats, or three caveats which I have listed out here, which still doesn't revolve. It is just a guideline. It operates through disaster response framework rather than creating a new heat wave specific statutory regime. It primarily addressed financial response. So we are waiting for harm to be done and subsequently talking about the finances. And third challenge, which is there, is uniform standards, institutional accountability, and coordination amongst these organizations.
Sorry to
India,
interrupt, ma'am. Please move towards conclusion.
the heat action plans, primarily, which is there, is talking about structural limits, which no implementation can cure. There are no statutory minimum content, no penalty for non-implementation. There are no individual right. And as we talk about, we have adopted why policy-centric adaptation, which we have right now. It has challenges in the form of fragmentation, uneven fiscal architecture, disproportionate burden, and weak accountability. The statutory floor and not a ceiling is what we propose, and the proposed model reforms, what we suggest is consolidate the notification with the technology in place, have statutory heat action plan minimum floor decided, have shaded rest, hydration, work, rest thing to be covered under the occupational heat and safety code, statutory, talking about the statutory relief mechanism and mandatory annual reporting, which has been incorporated from the UK and Kenya model from the international perspectives. Adaptation, the suggestion is to adaptation must move from executive discretion to a binding statutory duty. There should be a floor, not a ceiling, that preserves local flexibility. India's distributive, it is in a way distributive because India heat burdens falls on those who are least responsible for contributing it. It is working recognized because it has recognized in Rajit Singh case, but still there are procedural hazards because constitutional litigation is inaccessible to many. So what we have is a legal system that has already recognized this through this apex court, but a constitutional right against the adverse effects of climate, which has been recognized under emphasizing, must ensure that right is delivered and not just merely declared. Thank you so much.
Okay, thank you, participant. The jury has no question for you. Thank you.
Thank you, sir.
All right. Moving ahead, I invite Pujarini Behera to present. You're not audible.
Participant, kindly look into your audio. You are not audible. No, you are
No,
not
you are
audible.
not audible.
If there is subsisting issue, you can try the other things. We'll be moving ahead with the next presenter, then we'll call you. Yeah.
Okay, moving ahead, I now invite Dr. Simranjit Kaur.
Okay.
Hamid.
Yes, Dr. Kaur, you
A
can go
very good
ahead.
afternoon, everyone. Am I audible?
Yes.
But I cannot hear your voice.
Yes, you are audible.
You are audible. You are audible. You can go ahead. Yeah.
Okay, sir. So, thank you. So, my topic is synthetic sustainability. Okay, my topic is synthetic sustainability, AML governance of deepfake satellite evidence, phantom carbon credits, and AI-enabled green finance fraud. So the basic argument here is very simple. Today, environmental performance is no longer only an environmental issue. It can be converted into economic and financial value. A carbon credit, for example, can be traded, used for corporate environmental claims, or connected with green finance. Therefore, if the environmental evidence behind that asset is manipulated, the problem may go beyond environmental fraud. It can potentially become a financial integrity and AML governance problem. So let me first explain what is synthetic sustainability. Environmental markets increasingly depend on technologies such as satellite images, artificial intelligence, digital registries, and automated verification. The technologies can be extremely useful. For example, satellite images can help us monitor forest and land use. AI can help us to analyze the emissions and environmental changes. But at the same time, technology can also be manipulated. We can have fake projects, inflated emission reductions, false documentation. This creates a very important concern. Now, what happens when the false environmental information is accepted as genuine and then converted into a financial asset? This is where the environmental fraud can potentially become a financial fraud. The paper therefore identifies an important regulatory gap. Environmental verification and AML scrutiny do not always operate together. Now, this slide basically the evidence to asset conversion chain. This slide shows the central concept of our paper. The process starts with an environmental activity. Then that activity is measured through data. The data is subjected to validation or verification. After verification, information enters into registry. The registry may then result in the issuance of the carbon credit or another environmental asset. Finally, that asset can be traded, used in green finance, or used for a corporate environmental claim. Now, so the important chain is the environmental activity, measurement, verification, registry, asset, and the transaction. The key point is that environmental information can ultimately acquire the financial value. Therefore, we should not look only at whether the environment claim is true. We should also ask who benefits financially from that claim, where does the money go, and who owns the control. Who owns or controls this underlying project. Now, the paper develops four core concepts. The first the concept is synthetic additionality. This refers to a situation where the environment benefit is false and artificially created. For example, the claimed reduction in emissions may be much greater than the actual reduced. Second, verification laundering. Here, false information gains credibility because it passes through a very formal verification process. In simple terms, verification can give false information an appearance of legitimacy. Third is registry truth fallacy. Just because information appears in an official or a recognized registry does not automatically mean that the underlying environmental reality is genuine. A registry can, preserve a record, but it cannot necessarily prove that the original information was truthful. The fourth important concept is the evidence to asset conversion risk. This is perhaps the most important idea. Environment evidence can become institutional legitimacy, and institutional legitimacy can become a financial asset. So evidence itself can become economically valuable. Now, we come to the technological dimension. AI can be used positively for land use analysis, forest monitoring, emission detection, and environmental classification. However, AI can also create new risk. For example, we may have synthetic satellite images, altered images, false coordinates, or manipulated AI classification. This raises a different question. If AI generated image looks completely authentic, how do we know that it represents a real environmental event? Blockchain also does not completely solve this problem. Blockchain provides, a system. It basically records the information, and that recorded information is difficult to alter. But there is an important distinction. Blockchain can preserve the record, but it cannot necessarily guarantee the truth of the information entered into the record. Therefore, we need safeguards such as, metadata verification, source verification, processing history, explainable AI, and human oversight. The next part of this paper connects this
Participant,
theoretical
kindly
problem with
proceed with your
enforcement. The paper
participant.
discusses 2024 US enforcement proceedings concerning
Participant,
voluntary
kindly
carbon
proceed with
credits,
your
including
conclusion.
CFTC action involving alleged false, misleading, or inaccurate project information. The proceedings involve allegations that millions of additional credits were obtained and that carbon credits worth tens of millions of dollars were involved. The important point for our research is not simply that the individual enforcement action. The larger lesson is that environmental information can be converted into a financial value. If the project information is inflated, the number of credits can potentially be inflated. If the number of credits increases, their financial value can also increase. Therefore, environmental information, verification, carbon credits, and financial value is the system that it follows. This is why environmental integrity and financial integrity needs to be considered together. Now,
Please conclude
we
your
move
presentation, ma'am.
to we move to specifically AML. The carbon markets have several characteristics
Participant,
that
kindly
create
conclude your
risk. They
presentation.
involve intangible assets, cross-border transfers, intermediaries, corporate structures, beneficial ownership, opacity, and information asymmetry. These characteristics can make it difficult to identify the actual person benefiting from a transaction. Our paper also identifies certain potential AML red flags, for example, sudden and unusual credit issuance, changes in methodology, connection between project developers and verifiers, and transactions that do not appear consistent with the physical project activity. However, we make an important distinction that carbon fraud is not automatically money laundering. The existence of fraud does not by itself establishing money laundering. Rather, the point is that the environmental fraud can create an environment in which AML risk can arise, particularly when financial transaction and beneficial ownerships are involved. Now, let us look at the regulatory framework. At international level, we have the Article 6 of the Paris Agreement. We have the FATF framework. We have the IOSCO's 2024 work on voluntary carbon markets, particularly its good practices relating to market integrity, transparency, and market surveillance, etc. In India, Energy
Ma'am, please
Conservation Act
conclude
of
your
2001,
presentation.
Energy Conservation Amendment Act of
Participant, you are
2022,
exceeding
the
the
Carbon
time.
Credit
You
Trading
had
Scheme of
already exceeded it.
2023, we have Prevention of Money Laundering Act 2002. The important observation is that these frameworks operate across different regulatory
Host, am I audible
areas.
to you?
The challenge is to connect
Yes,
them
sir.
effectively. So,
Okay.
based on these concerns, our paper proposes an integrated AML governance approach. The first element is geospatial and environmental provenance. We need to know where environmental evidence comes from and how it was generated. Second is beneficial ownership verification. We should identify who ultimately owns or benefits from the project. Third is project level financial due diligence. The financial transaction connected with the environmental project should be examined. Fourth, cross-registry reconciliation. Information across different registries and databases should be compared to identify inconsistency. Fifth is explainable AI transaction monitoring. AI can itself be used to detect unusual patterns, but decision-making process should be understandable. Sixth is community and independent verification. We should not depend entirely on automated systems or single verifier. Seventh is environmental financial intelligence interface, environmental regulators and financial interface. Environmental regulators and financial intelligence or AML authorities need mechanism to share the relevant information. Finally, we need risk-based governance of tokenized credits, particularly where environmental assets are converted into digital or tokenized financial instruments. Lastly, I would like to conclude. Let us conclude, the main argument with the main core theme of our paper. The central problem is not technology itself. Satellite images, AI, blockchain, and digital registries can significantly improve environmental markets. The problem arises when the technologies create confidence without sufficient verification. Synthetic sustainability explains the gap between the, exploits the gap between the environmental verification and AML system. False environmental evidence can acquire institutional legitimacy and then financial legitimacy. Deepfake represents an emerging technological capability, while existing enforcement demonstrates that environmental information can already be converted into significant financial value. Therefore, our solution is integration, not indiscriminate criminalization. We do not suggest that every environmental error should become an AML offense. Instead, we propose a stronger coordination between environmental verification, market regulation, and financial due diligence and AML governance. And thus, the final principle of our paper is evidence verification, registry, asset transaction, and beneficiary. At every stage of this chain, we should ask one fundamental question: is the information genuine, and who ultimately benefits from it? If the answer to that question, if we can answer to that question effectively, we can move from merely ensuring
Participant, you
integrity
had
to
exceeded the
ensuring
time.
broader
That's enough.
environmental financial integrity.
That's enough.
Thank you so
Participant,
much.
that's enough. You had exceeded the time.
Is there any question?
Uh, you had exceeded so much time. We
Am
can't
I
take
audible?
any question. Yes, you are audible. We can't take any further questions. Thank you.
I cannot hear.
All right.
One more
Now,
note to all the participants before proceeding further. No extra time would be allotted since this was the first instance we noticed that the participants were having issues. They can't listen us or they can't hear us. Uh, would be simply stop the presenter if the presenter has exceeded their time. Yes, host, you can move ahead. We had already
Yes,
exceeded much time.
right. Now we move to our next presenter, Mr. Sivadarshan.
Am I audible?
Yes, you can start.
Yes. Good afternoon, respected judges and fellow participants. Thank you for the opportunity to present today. My name is Sivadarshan, and my paper is titled Beyond Compliance, a Behavioral Paradigm for Climate Justice and Environmental Governance. Over the next few minutes, I will walk you through the central argument and how I arrived at it. So let me begin with the central argument of this paper. In one sentence, behavioral foundations are not peripheral to environmental law, they are legal necessities. Having a legal right on paper does not by itself guarantee that people comply with it in practice. There are 6 behavioral variables, which I will now introduce shortly, that determine whether a law actually functions once it leaves the courtroom and enters everyday life. Based on this understanding, I am proposing what I call a behavioral paradigm, an approach that treats behavior as something that law must account for rather than something addressed only after the fact. I test this paradigm across 3 jurisdictions: India, Bangladesh, and Pakistan. Before going further, a brief note on context. South Asia contributes very little to global greenhouse gas emission, yet it remains among the regions most exposed to climate-related harm. India, Bangladesh, and Pakistan have each responded by building constitutional guarantees and dedicated institutions. This framework looks comprehensive on paper. Existing research on climate justice in this region tend to follow one of two paths. One strand focuses on distributive rights, examining who bears a disproportionate share of the climate burden and how legal entitlements might correct that imbalance. The other strand focuses on institutional accountability, asking whether courts and regulators are actually fulfilling their statutory responsibilities. Both strands share a common assumption that granting rights and building institutions will on their own produce compliance. That assumption does not hold. Non-compliance, weak participation, and inconsistent enforcement persist even where the legal architecture appears well developed. This is the real gap I am pointing to, an under-examined behavioral dimension of environmental law. There are 6 variables I written throughout this paper. Trust, which reflects how much confidence people place in an institution. Risk perception, or how seriously environmental harm is actually taken. Collective responsibility, meaning whether people feel the outcome is partly theirs to bear. Participation, or whether people actually engage with the process available to them. Compliance, the straightforward observance of legal obligation. And adaptive resilience, the capacity of institution and community to recover when something goes wrong. Together, these 6 variables determine whether a law succeeds in practice regardless of how well it is drafted. Let us look briefly at the actual legal architecture. India relies on Article 48A and Article 51A, Clause G of the Constitution, the Environmental Protection Act of 1986, and the National Green Tribunal Act of 2010. Bangladesh relies on Environmental Conservation Act of 1995. Pakistan relies on its own Environmental Protection Act. So the landmark case laws. This pattern becomes even clearer in case law. In 1987, MC Mehta versus Union of India established the absolute liability doctrine in India. In 1996, Vellore Citizens Welfare Forum case introduced the precautionary principle and polluter pay principle. In 1997, the Farooq case in Bangladesh expanded who is permitted to bring a matter before the court. And in 2015, the Lahari case in Pakistan led to an entire climate change commission being established to monitor implementation. This brings me to the central tension of this paper. On one side strand, the compliance-driven model, sanction-based, dependent on litigation, and built on the assumption that people act as rational. On the other side is what I call the behavioral paradigm, centered on legitimacy, designed around participation, and focus on trust. So the existing approach are real strength. Court across the region have genuinely bold and reading environmental protection into fundamental rights. Its weakness is that it reaches only those who can afford to litigate. Behavior in this framework is not a footnote. It is a legal necessity. So the findings, this leads me to 3 findings. First, legal sophistication in this area has clearly outpaced behavioral understanding. Second, compliance is not automatic. And third, granting people the right to bring a case to court does not on its own translate into their actual participation. Suggestions. Based on his findings, I propose three suggestions. First, being affected communities into the rule-making process itself rather than involving them only once matter reach litigation. Second, make enforcement transparent and genuinely public. And third, treat institutional trust as something that must be continually earned rather than something granted automatically the moment an institution is created. Conclusion and thank you. Let me close with this. The durability of environmental governance depends less on how well this legal text is written and more on whether institutions earn the trust of people they govern and whether that trust translates into compliance. Climate justice in South Asia remains, in this sense, an unfinished task. And what remains unfinished, I would argue, is not the law itself. It is the behavior the law has always depended on. Thank you very much for your attention.
Okay, thank you, participant. The jury has no question for you. Thank you.
Thank you.
Now I would like to invite Miss Surbhi to present.
Am I audible?
Yes. You can start.
Okay. Good afternoon. Thank you for this opportunity. I'm Surbhi, PhD research scholar at VM Salgaonkar College of Law, Goa. My paper is titled Green Only on Paper, Mandatory Corporate Social Responsibility and Environmental Justice Deficit in Goa. I ask a simple question about a law India is proud of. And the answer is uncomfortable. The climate justice begins where economic activity meets ecological vulnerability. India moved early in 2013. It became the first country to make CSR spending mandatory and Schedule 7 list ensuring environmental sustainability as an eligible head of spend under the Companies Act. My focus is Goa, India's smallest state by area, a Western Ghat biodiversity hotspot that nonetheless carries an industrial load far out of proportion to its size. Mining, manufacturing, dense tourism, harms are concentrated, and the regulatory capacity is thin. The aim of paper is direct to test whether mandatory CSR produces real environmental repair in Goa or only formal compliance. The methodology used is doctrinal as well as empirical. The core problem is simple. There is a gap between statutory design and ecological effect. Section 135 mandates spending, not repair. It ties duty to profit, not to harm. It rewards procedure over outcomes. The local area preference is non binding. The verification is self reported. In short, the law measures paperwork, not ecological recovery. The data from Goa makes that visible. In 2023-24, only 37 companies reported in an environmental activity in the state, and only 23 of those did ecological work. Since 2018-19 till 2023-24, just 92 companies have ever done so, while number of registered companies rose from 8,000 something to 11,000 something. That is participation gap. Then there is episodic participation. 61 of those 92 appear in a single year and never again, though ecological restoration is a multi-year work. Reported environmental CSR has risen sharply nationally between 2018-19 and 2024-25 and 14-fold in Goa. But air and water quality have not improved. 7 of 10 ambient air stations exceeded PM10 standard. The Sal River biochemical oxygen demand is far above bathing norms. The structure secures legitimacy on paper while outcomes deteriorate on ground. This is not a call to invent a new instrument. India already has the statutory chases. It needs a redesign. Four practical reforms would align CSR with environmental justice. First, require independent verification. Third party technical assurance filed with the registrar and with State Pollution Control Board. Second, create a harm and locality nexus, convert the local area preference into an enforceable duty for companies in a ecologically stressed zones so that remediation beyond compliance count. Third, report outcomes, not outlays. Hectares restored, liters recharged, tons diverted, survival rates of saplings planted, not merely the number of saplings planted. Fourth, adopt a place based framework. Aligns CSR to sustainable development goals 6, 13, 14, 15, and 12 also. Establish district committees, including affected panchayats, and create a clear grievance channel. India mandated CSR a decade before most jurisdictions did, and the number have been read as proof that the experiment works. However, Goa evidence needs more careful conclusion where environmental need is greatest. The result is that an environmental justice deficit produced as much by statutory design as by corporate choices. The good news is that design defects can be redesigns. These are practical, implementable fixes that would shift CSR from paperwork to repair. Thank you. Any questions?
Okay, there is no question from our end. Thank you, Shruti.
Thank you.
Now we move to our next presenter, Ms. Sugandha. You are not visible.
Am I audible?
Yes.
I cannot hear you properly, so I hope I'm audible.
Yes. You can start.
Uh, Good afternoon, everyone. I'm Sugandha. I'm a student enrolled in BVLLP. So, my topic is from heat risk to heat justice, a rights based framework for extreme heat governance in India and Bangladesh. Now, extreme heat is generally approached as a problem of climate risk, public health, or disaster management. The paper asks a different question: whether exposure to extreme heat and the capacity to adapt are unequally and when the capacity to adapt are unequally distributed, should heat governance itself be evaluated as a question of climate justice and human rights? So I would like to So, explore this comparative analysis of India and Bangladesh and propose a rights-based framework for evaluating extreme heat governance. My central argument will be that we need to move from managing heat as a hazard to governing heat as a question of justice. The problem is extreme heat as a justice issue. Extreme heat is not socially neutral. Exposure and adaptive capacity vary according to occupation, income, housing, access to water and healthcare, and some other structural conditions. Now, this creates an important distinction between aggregate risk reduction and equitable protection. A heat warning may be technically successful, but its value is different for someone who can remain indoors compared to someone who has to work outdoors for livelihood and requires continued exposure to heat. Therefore, the existence of a heat action plan by itself cannot establish climate justice. We also need to ask who is actually protected and whether this protection corresponds to vulnerability. This paper therefore asks to what extent do legal policy and frameworks governing extreme heat in India and Bangladesh operationalize the climate justice. I use comparative doctrinal and legal analysis alongside qualitative policy analysis, examining constitutional principles, climate adaptation policies, disaster governance framework, and heat governance instruments. Importantly, I would distinguish between formal governance architecture and actual implementation. The existence of a legal or policy provision does not by itself establish that it has produced equitable outcomes. The climate justice lens. I evaluate heat governance through four dimensions of justice: distributive justice, recognitional justice, procedural justice, and restorative justice. Distributive justice asks who bears heat related risk and who receives the protection. Recognitional justice recognizes the vulnerability of those who are exposed to heat and how much heat is each individual exposed to. The procedural justice asks about who participates in decision making. And at last, restorative justice asks what happens when governance fails. Together, these dimensions allow us to evaluate not simply whether a heat policy exists, but whether the governance process itself is just. Now, from heat action plans to a rights-based protection, with a focus on India. India provides an important constitutional foundation for rights-based protection under Article 21 and cases such as M.K. Rajne versus Union of India, Supreme Court. Um, this is particularly relevant to extreme heat because climate impact can affect health disproportionately, especially where people have unequal capacity to adapt. And at policy level, India has developed heat action plans and early warning mechanisms, including Ahmedabad model. The question in my paper therefore asks whether constitutional recognition is translated into proportionate protection for those most vulnerable to extreme heat. Bangladesh. Bangladesh also provides a particularly useful constitutional comparison under Article 32 and Article 18A. And at the policy level, the National Adaptation Plan 2023 to 2050 provides a broader framework for climate resilience and recognizes the importance of addressing vulnerable populations and climate hazards. The constitutional roots are different from India, but they point toward a similar question: how do we translate a general right to life and environmental protection into concrete and equitable protection against an increasingly unequal climate hazard?
Participant, you can move to the conclusion and your findings.
Yes, sir. So comparative finding. This this paper produces a central finding of paper. Both countries have it developed significant anticipatory governance capacity, but a common gap is therefore not simply the absence of policy, but a differentiated but difficulty of translating differentiated vulnerability into differentiated protection. A proposed rights-based heat governance framework will be that first, right-based protection should be there, second, vulnerability-sensitive adaptation, third, recognition of structural vulnerability, and fourth, meaningful participation. Fifth, accountability and effective institutional response when protection fails. Conclusion. To conclude, India and Bangladesh demonstrate meaningful progress towards anticipatory heat governance, but preparedness and aggregate risk reduction are not sufficient measures of justice. The next stage of adaptation must also address equity, recognition, participation, and accountability. And so I return to the central proposition of this paper. We need to move from managing heat as a hazard to governing heat as a question of justice. Thank you.
Okay, thank you, participant. We don't have any question for you. Thank you.
Now we move to our next presenter. I invite Ms. Poonam Gulati. Please turn on your camera.
I've turned the camera on, ma'am. Am I visible?
No. Yes, you're visible.
Am I visible?
Yes.
Participant, are you co-authored with the other participant who is present currently? Just
No.
check once.
No, sir. That's
Is my
different one.
Okay.
Is my PPT visible?
It's not visible.
No.
It's just uploading. By the time it gets uploaded, I'd like to introduce my topic as well as my co-author. Good afternoon, respected chair, members of the panel, and dear participants. I'll be presenting on the topic climate justice beyond atmosphere, governing space mining, and clear energy transition. This paper is co-authored with me by Dr. Mahipal Lathar, who's an associate professor of practice at the National Forensic Sciences University, New Delhi. He's also a former joint director legal at the Ministry of Defense, Government of India. As I just mentioned my topic, I would like to go to the next slide. Firstly, our paper is addressing a very critical topic, but basically we are talking about the climate justice, which is largely ignored so far as the orbital frontier is concerned. And while the clean energy transition aims to heal the ecological wounds inflicted by fossil fuel, it rests on a massive, heavy materialistic foundation. Decarbonization requires unprecedented quantities of essential mineral to build electric cars, wind turbines, batteries, and electronic grids. So it has been noticed according to the International Energy Agency that electric vehicles require 6 times more mineral inputs so far as a conventional car is concerned, and an onshore wind farm requires 9 times more minerals so far as a natural gas plant is considered. The critical mineral squeeze has turned global eyes towards the outer space. Outer space mining and asteroid mining are increasingly seen as an ultimate green alternative, promising raw materials in abundance without a visible ecological scar or local exploitation so far as the terrestrial mining is concerned. In our research, we argue that environmental optimism is both premature and normative. In practice, current life cycle assessments showing space mining environments benefits are highly conditional, limited, and contingent. So we must ask, does space mining truly offer an equitable response, or does it simply replicate terrestrial injustices under the green facade? The core problem here lies in our legal system. While the Outer Space Treaties establish foundational principles such as peaceful use, cooperation, non-appropriation, it is clear. It is basically clear through even the Moon Agreement that an attempt has been made to codify the common heritage of mankind principle, but this principle remains unratified and unsupported by major spacefaring nations. Instead, we see national laws and multilateral initiatives like the Artemis Accord advancing commercial extraction rights far more rapidly than the universal equity-oriented international rules. So we see justice deficit. The first irregularity that we see as a gap is the jurisdictional discontinuity, the artificial separation of environmental and climate governance on earth and space law. Secondly, we face a crisis of material inequality masquerading as formal freedom. The formal freedom of expression and expression of exploitation in spaces meaningless to the nations without technological capacity. And furthermore, it is currently seen that no common climate or environmental impact assessment and no institutional mechanism shares mandates beneficial sharing. For this purpose, we have also, for the purpose of the study, we have also made a comparison of the extremes so far as regimes related to the deep sea and Antarctica is concerned. And to bridge the deficit, we are looking at this. It shows that so far as the seabed is concerned, how to operationalize common heritage principles through mandatory benefit sharing. Meanwhile, in the Antarctic treaty system, it offers a powerful comparative model for strict environmental preservation, emphasizing scientific cooperation over the commercial extraction. Okay, drawing from this, basically, we have proposed in our contribution, we have proposed two things. Firstly, is the climate justice continuity principle. And in order to basically, this principle is simple, non-negotiable. It talks about a simple non-negotiable truth that if extraction of resources has to be done, it does not have to be at the cost of the environment around it. So for this purpose, an orbital just transaction framework needs to be worked out. And this framework should have distinct pillars. Firstly, it should be necessity based authorization should be there. Circularity first has to be checked. Complete life cycle assessment has to be done. Differentiation responsibility has to be checked. Anti enclosure safeguards have to be checked. Then anti enclosure safeguards have to be implemented, and mandatory benefit sharing is very, very essential. The wealth generated from commons must be directly reinvested to fund global climate adaptation and mitigation efforts, particularly for vulnerable nations in the global south. Uh, this is the next thing I would like to talk about here is the space resource extraction. It can be normalized as a sustainable
Participant,
practice
you
unless
can
it
come to
rests.
your conclusions and recommendations.
Sure. As a conclusion, this is the last slide. Next slide. The clean energy transition is essential, but it is not politically or environmentally innocent. The decision regarding this is simple. The space mining can only contribute to global sustainability if law arrives before entitlement, oversight before damage, and equality before extraction. That will be all from my side. Any questions, please?
Okay, so what are the legislative policies like you had looked into, which can be the model policies across the world?
So model policy for the future, sir, that's what we are discussing.
No, no, like for the implemented countries, there are few countries who have such kind of policy directions they are working right now. Have you looked into it?
Yeah,
That's
yeah,
what
of
I'm
course.
asking.
We have
So,
made
yes,
I think sir would like to speak.
yes, yes, definitely, yeah.
Sir, I'll
You,
take on this. This is actually space law, as it has been said. It is for the all global good, humanity. Everything is fine, but the core issue here remains with the even outer space treaty, the even the Artemis Accord, which was recent. So what happens is that territorial who owns it. Now the Karman line, as was discussed by the presenter, my co-author, that 100 kilometers, approximately 100 kilometers. But there, who will monitor? Who will do? The space faring nations are very few, limited. Not all nations globally are space faring. So it, how can it be for the global good? So there is a difference between monitoring the environment and the extraction when you can physically see it, when you, there's a territorial distinction about the ownership and the responsibility and accountability accordingly. But on, in the space, if moon extraction is there, in the space extraction is there, who will challenge, whether, who will say, who will give the evidence about whether the environment, the debris management, the issue, environment challenges have come place? Only selected few. And if there is a consortium of that, so accordingly, based on these lines, like on Antarctica, even in the remote areas where it is less run by other countries, they have, even in the sea they have ownership and accountability
yes,
responsibility.
Dr.
So
Mahipal, yeah, on yes, like on this, I want to reflect. This is one of the most closest topic I can think and tell you. Like in 2022 and 23, I had been into one of the commission in India along with NUJS, if you know, National University of Judicial
yes,
Sciences is having one of the center related to space law and aviation. So
yes,
in 2022 and 23, I had been one of the core resource person who dealt with the jurisdictions of our moon, like how to deal with the pressing jurisdictional policies, how to decide what area a country, because nowadays every country who is capable enough to go to moon is taken up a plot that this is my demarcated area. So in coming days, in the next 20, 30 years, every country will come with the clash. No, no, this not yours, this my, this not yours, this is. So for that, like time and again, there are conclaves. There time and again there are talks which is happening on a multilateral level. But again, these things are very much unclear. So what I can tell you from my study and the researches which we did in 2023, uh, like these are the demarcations where we have to look into, not a frictional based study. Like, since I know these are the thing, like determining a jurisdiction of a moon or determining a policy which is non-existent, we can just come up with the suggestions. But again, since the topics are under research, we cannot just write a simple essay without any authorities. So for this aspect, I try to refer you guys. Like, you can both of you, we are the well part of this research community. We have to look into the aspect, what are the settled principle. As you mentioned, the settled principle is the jurisdiction over the land, the jurisdiction over the oceans. So we have to refer those, how the settled principle has developed thoroughly, and on that notes only we can demarcate the jurisdictions over the other extraterrestrial and the terrestrial bodies. That's how I think your study also requires to further up with such deep resources study. I believe I made my point clear to you, Dr. Maipal.
Yes, sir. Thank you so much, sir.
Yeah.
And it will now, the international law defines the eco and geostrategic diplomatic interest globe at that time. And the
Yes.
dispute is still good for the mankind till the time it is a dispute, and it is dispute will raise the issue of concern of environmental
Okay. Okay.
safety
Thank you.
and other issues. Because,
Yes.
thank you.
One more question, participant. You guys would be presenting one more paper, because one more title is listed upon your name.
Yes, sir.
Yes,
Sir
sir.
will be presented.
I'll be the one
Okay. 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 All
with the
right.
permission of
Move
the
ahead.
chair.
Yes.
Thank
Yes.
you.
Yes.
Definitely. Move ahead.
Ma'am, please upload the PPT,
Sure,
ma'am.
sir. Sure, sir.
Thank you.
So it's up loading.
Okay, till then I start with the topic. May I start with the permission of the chair, sir?
Yes. Yes. You can start.
Good afternoon, everyone. Esteemed chair and dear colleagues. Today, our research paper titled Satellites as Climate Witnesses, an evidentiary protocol for Earth observation, data in climate litigation, and loss and damage claims. Our research paper basically begins from a simple but increasingly important reality. Satellites are no longer merely the instruments for weather forecasting, scientific research for mapping. Earth observation system now record phenomena that may subsequently become important legal evidence in the form of flooding, forest logs, glacier retreat, coastal erosion, etc. Our core argument is of the paper is that a satellite does not determine whether state, corporation, or individual is just legally liable. It also observes physical conditions, and these observations help establish attribution, causation, and responsibility when corroborated with other evidences. So I would like to say that satellites should be climate witnesses, not climate judges. With this, I would like to start my presentation. Now, coming to importance relevance of the satellite evidence. Now, climate harm does not necessarily wait for investigators. A flash flood may alter a landscape within hours. Wildfire evidence may disappear after vegetation regenerates. Earth observation archives provide some traditional investigation, often cannot provide the temporal continuity. Now, if you see, Sentinel-1, I would like to take the example of that Copernicus Sentinel-1 uses Charlie band, C band, we call it, synthetic aperture radar, and can acquire information through clouds and rains, and both during the day as well as night. Now, this characteristic is particularly relevant and important in cyclones and floods, when optical imagery may be obstructed by cloud cover at times. So, satellite evidence establishes four especially important things, we could say. It's a pre-event baseline, change over time, physical conditions where inspection is difficult, and post-disaster recovery and its assessment. But there is a key legal warning here that visibility is not liability. Next slide, please. A satellite image is not a legal fact. What a judge sees in the court, a colorful image, which is usually not what the satellite originally recorded. A remote sensing instrument measures electromagnetic energy. There are measurements which may subsequently undergo radiometric calibrations, atmospheric corrections, geometric corrections, geolocations, cloud screening, lot of technical things that change. So means there are four forms of resolution which we can say that matters legally. One is spatial resolution. Spatial resolution, what it tells us about how much ground is represented by a pixel, like in a photograph we say it. Now, temporal resolution tells us how frequently the area can be observed. And the spectral resolution addresses and concerns about the wavelength a sensor can distinguish. Now, radiometric resolution is about the ability to distinguish the differences in measured energy. NASA has also expressly identified these four dimensions of remote sensing resolution. Now, there are, based on this, what we have understood, there are five separate evidentiary questions we can talk about. Is it authentic? Is the measurement scientifically reliable? Is it relevant to the imposed legal issue in the case? And what is the uncertainty that remains? And what are the corroborating evidence that exists? The apparent simplicity of the final image may hide considerable scientific complexity. This is what our research calls it as evidentiary compression. Evidentiary compression. Next slide, please. Next slide, ma'am. Now, the chain of inference. Okay. A major danger in technological complexity and environmental litigation is what I would call inferential jumping. Inferential jumping means jumping of the inference that is moving directly from image to the liability. Therefore, in our research, the evidentiary reasoning has five distinct stages. Stage one is about the physical observation. Stage two is immediate source or event attribution to the source. Stage three is attribution to the climate. And stage four is about the attribution of the actors. And of course, the stage five, the last is the legal causation. So, now in 2025 NISTIR 8575, it has emphasized that we all remember methane emission estimates derived from the remote sensing plumes that depends upon what? Transparent methodologies, validation, quality assessment, and traceability. So, what is the broader lesson from
Dr. Manipal, you
NISTIR
can go
8575?
to your
That the
recommendation.
greater the legal proposition, the greater is the evidentiary burden. A satellite may contribute at every stage, but ordinarily it does not complete the entire chain of attribution and accountability.
Sir, please conclude the presentation.
Okay. Ma'am, please come to slide 12, ma'am. Can I take 1 minute more, ma'am, before the conclusion? If it is 30
Yes,
seconds,
Doctor.
if it is allowed.
Yes, Doctor Mahipal, go ahead with your conclusions and other thing. Yeah.
Because it would be meaningful to give something. Please come out to slide 6, ma'am. Slide 6, please. Costa Rica versus Nicaragua in 2015. What happened in this judgment? International Court of Justice, they considered the satellite and aerial images and found that imagery was relied upon by Nicaragua insufficient to prove the existence of that natural channel that was alleged in the case. So it means this case by the International Court of Justice that satellite imagery is not automatically conclusive in nature because it appears objective. Even in the 2018 compensation judgment, $17,600, two satellite images were there. Their claim failed because invoices which establish the geographical area covered, it did not establish that. The invoice of this billing, it did not establish what all geographical area covered was built for. Although later court awarded $15,960 for those satellite images purchased on different parameters. So provenance, purpose, and connection is that matters. There are two cases we should know, and it gives us objectively understanding about it. And in Dwarkanath Chaudhary case of NGT case of 27th April 2026 recent, tribunal has NGT tribunal has Green Tribunal has discussed limitations of remote sensing for wetland mapping. It noted that many classification thresholds require human judgment and therefore emphasized that ground truthing and cooperation between remote sensing GIS specialist and wetland ecologist is relevant and important, including here this case it gives us an inference that even incorporating AI in today's era in this mapping, again, it is going to the central argument remains the same. The human involvement, human judgment is critical and important while deciding. So, I'll conclude in the next 30 seconds. Thank you so much for a little more time because this gives us real perspective about the realistic with the cases that have been decided at the International Court of Justice and as well as in the Indian National Green Tribunal in India. So I would like to conclude going back to the central distinction. Basically, I'll say satellite evidence has enormous potential. It is evident by the discussions as we have carried out. It can observe places where we inspectors or the regulatory bodies can't reach. It can preserve conditions which can later disappear. Now, it can also help us in reconstructing the environmental change over years or even longer period like decades or centuries. It can detect the emissions, assist us in disaster assessment, therefore gradually disaster management, monitoring the restoration, and of course it challenges the inaccurate environment claims that has been made. Now, what we have proposed in our research that satellite climate evidence protocol, SCEP we have called it, it rests upon various factors with traceability, scientific validation, processing disclosures, AI transparency, digital chain of custody, of course, that is primary in establishing the integrity of the evidence placed before any court of law, proportionate corroboration, and independent, objective technical review. Therefore, I would like to my final concluding line for the audience and for the honorable chair would be that the future of climate justice may increasingly depend upon what we can see from orbit, but justice itself must still be determined on earth through sciences, the evidence, and the law. Thank you. Thank you so much.
Thank you.
Okay, thank you, participants. The jury don't have any further question. Like your paper is very clear. So thank you for your presentation.
Thank you.
Thank you so much, everyone, for
Okay,
the patient
so
hearing and for the jury to be very supportive towards the academic meaningful research. You have given positive impetus to us. Thank you so much,
Thank
sir.
you.
Thank you, everyone.
That concludes the final presentation of today's technical session 1 of the South Asian Conference on Sustainability and Climate Justice 2026. I would like to extend my heartfelt congratulations to all our presenters for successfully presenting their research before this distinguished international academic forum. Each presentation reflected substantial academic effort, critical research, diverse perspectives, and meaningful engagement with the pressing issues of climate change, sustainability, environmental governance, ecological protection, environmental rights, and even climate justice. The quality and the diversity of the research presented today have contributed significantly to the academic objectives of this conference. Thank you.